Yeah, please, Your Lordship.
Yes.
Your Lordship, may be pleased to mention hearing item number 27, 28, and 29.
27, 28, and 29.
Yes, Your Lordship. Your Lordship.
Separate matters?
Yes.
Separate. Okay.
Your
Yes, 7, 27.
27, 28, and 29, Your Lordship.
You are for the state.
Your Lordship, this matter has been endorsed to me, Your Lordship. So, Your Lordship, there's some clarification I need to make from the department again. I feel it has already been filed, but there's some clarification I need to. So,
Okay,
another
yeah.
3 weeks may be granted.
Item 27, who is for the petitioner?
For the state responding, Your Lordship.
Who is for the petitioner?
My
You
senior
want
is for the,
petitioner?
yes, my senior is for the petitioner.
27, Yangarvati.
Yes,
Okay, MS.
Asikire.
Okay. Learned counsel.
Your lordship,
behalf of,
my apology, your lordship, your lordship, I made some mistake, your lordship. Lordship, I have to make a mention, your lordship. My apology, your lordship.
Yes.
Your Lordship, then I'm mentioning on behalf of my senior for item 27.
now it is your turn. Okay.
Kindly grant us 2 weeks' time since my senior is indisposed.
Indisposed.
Yes.
Okay, MS so and so, learned counsel appearing for Mr. Yangarvati, learned counsel for the petition has submitted that Mr. Yangarvati is indisposed and has therefore prayed that matter case be listed after 2 weeks. State council available? The prayer is made with the consent of the state council for the state state council. Please. Yes,
May it please, my lord. Lordship, I beg to mention item number 8. I have received affidavit in opposition, so allow me to file affidavit in reply.
Okay.
To the affidavit in opposition. In the meantime, lordship,
by
Let-
affidavit of opposition by whom?
by the petitioner.
Huh? You are for?
I am for the petitioner. The
Affidavit
respondent
of
have,
opposition by whom? Affidavit of opposition filed by whom?
I want to reply to their
Ah,
affidavit in
who has
opposition.
filed the affidavit of opposition? State?
State, lordship.
Okay,
In the meantime, lordship, it needs emergency disposal. Let the matter be fixed on 16th May for admission hearing, lordship. In the meantime, I'll file my affidavit in reply.
Mr. MS J. Jimoni, learned counsel for the petitioner has paid for 2 weeks' time to file affidavit in reply to the affidavit of opposition filed by the state respondents.
Lordship.
Those of, who is for the state?
Lordship, I'm for the state.
Mr.
Insuka, Lordship.
Okay, learned counsel for the state respondent is present. So the prayer is allowed as sought for by the learned counsel for the parties, list the case on 16.
16th, lordship. Obliged, lordship.
Lordship.
8 and 9 together. Am I Jimoni?
Yes, yes, lordship. The contempt is
Okay.
also listed.
You want to
on-
file in the read petition?
In the read petition.
Okay.
lordship.
Read petition. 9.
Please, your lordship. I beg to mention item number 30 and 31, lordship. The principal counsel is indisposed. Let it come after 4 weeks, lordship.
Who is Mr. R. Iralo?
No. For the respondent, Mr. N. Kelly come, lordship.
Okay, Mr.
CD rooms, lordship.
C.D. Rongsong, learned counsel appearing on behalf of Mr. N. K. Wickham,
Lordship.
learned counsel for the respondent in 31, FA 4/2014 has submitted that Mr. Wickham is indisposed and the case be posted after 4 weeks. Petitioner, appellant, you have informed,
Yes, Lordship.
you are for the appellant,
Yes, I'm for that.
MS.
Martini.
Okay, learned counsel for the appellant is present and has no objection to proceed prayer. Let that rest, considering the ground cited. Commander prayer is allowed, leaves the case after 4 weeks, cases after 4 weeks. Leaves the appeals.
May please, Lordship, Lordship, I beg to mention item 22 and 23. Lordship, here the matter is still now before the Manpower Rationalization Committee for recommendation. So Lordship, I pray that some time may be given to us.
Okay. Akin Risham. You are,
No, I'm appearing on his behalf.
your name?
D. Soto.
B. Soto, learned counsel appearing for Mr. A. Jho. Learned counsel for the petitioner is present. B. Sukhoi, learned additional advocate general,
Yes, Your Lordship.
has submitted that the matter of commissioner appointment
No, for regularization, what?
for regulation of the petitioner is before, under consideration of the manpower regularization,
What charge regularization?
manpower regulation committee or
Manpower Rationalization Committee.
rationalization committee.
Yes.
And has therefore prayed the listing of the cases after
Lordship, make it 4 weeks, Your Lordship.
4 weeks,
Yes, Your Lordship.
4 weeks. In order to enable her to provide up to date status.
Lordship.
Because as the prayer is not opposed by the learned counsel, but a petitioner, leaves the cases after 4 weeks.
Okay, much blood.
My lord, may I also beg to mention item number 24 on behalf of P. Pius Lutha.
Okay.
My lord, may this matter be listed on Thursday, 11th of this month.
11, why 11?
Just convenient for
24.
both the parties.
Hmm? Criminal appeal. You have not taken steps.
Here, my lord, I'm not in this matter, so I'm not aware of that.
Okay. Sir, so learned counsel. Appearing for Mr. P. Pius Lotha, learned counsel for the applicant appellate, has paid for listing of the case after 1 week. Mr. N. K. Agami, learned public prosecutor for the state respondent is present and has no objection to said prayer. The prayer is allowed. Lays the case after a week.
My lord, may I also beg to mention item number 1 and 2 on behalf of my senior Ajo. My lord, may this matter be listed on 16th of this month.
16th.
16, my lord.
Okay, mention, there is a mention memo.
My apology, my lord. 15, Monday.
Okay. Mr. So-and-so, learned counsel, appearing for Mr. Ajo,
Ajo.
learned counsel for the respondent,
Uh,
private respondent,
item number 1 respondent to
private respondent in, private respondent. In, okay, 1, and for the petitioner in, for the petitioners in 2.
2.
Has paid for listing of the listing of both the writ petitions, comma, with the consent of the learned counsel for the other parties, comma, on 15,
15, my lord.
15/5/2023. First of. The prayer is allowed, list the case. Prayer is allowed as the parties have already submitted a mention memo yesterday. The prayer is allowed, list the case on 15 as prayed for. You are for the state respondent. Mr. So-and-so, learned counsel, learned state counsel is present.
Much obliged, my lord.
May please lordship, I beg to mention item number 12.
12,
Yes, lordship. And for respondent number 1, we're yet to file our affidavit, so kindly grant 3 weeks time.
okay. You are for petitioner.
Yes, lordship.
Your name, please.
Asin Lalong Kumar.
Okay, learned counsel for the petitioner is present. MS,
Biketsono.
learned counsel for the respondent number 1 has prayed for
3 weeks.
and is granted 3 weeks to file counter affidavit on behalf of the respondent number 1. Lays the case after 3 weeks.
May you please, lordship, your lordship, I beg to mention item 17. Let the matter be listed after a week. I've already filed my counter, your lordship.
Okay. You have informed the other side.
Yes,
MS
your lordship. And for the petitioner.
for the,
Reiterate.
okay, learned counsel for the petitioner is present. MS. No. Your name, please, I have forgotten.
Mrs. Lucy, your lordship.
Yes. Learned state counsel has paid for listing of the case after a week.
Obliged, your lordship.
The prayer is allowed, list the case after 3 weeks, 1 week, after a week.
May I please, your lordship? Lordship, I beg to mention item number 21. On behalf of,
21.
yes, lordship. On behalf of the counsel for the appellant, Mr. Fosico Forte. Lordship, he is in bereavement, your lordship. So if your lordship, may kindly list this matter after 2 weeks.
And who is for the respondent? You have informed.
Yes, your lordship.
I'm for respondent number 1 to 4.
Okay,
Yes, your lordship.
Mr.
M. Vero, your lordship.
M. Vero, learned counsel has submitted that Mr. Fosego Hotel learned counsel for the appellant is in bereavement. So he has thus paid for listing of the case after
2 weeks, my lord.
3 weeks.
Yes, lordship.
Okay, 3 weeks. MS so-and-so,
Appearing on behalf of PN Sharma.
appearing on behalf of Mr. B. N. Sharma, learned counsel for the respondent number 1 to 4 is in attendance and has no objection to the said prayer. Okay, the prayer is allowed, is the case after 3 weeks.
Obliged, my lord.
My pleasure, Lordship. Lordship, I beg to mention item number 10 on behalf of Inaholi. Lordship, we can list this matter after 3 weeks.
You're for
I'm for the state.
state.
Yes, yes.
I'm for the petitioner, Lordship.
Okay, Mr. Moajami, learned counsel for the petitioner is present. On the prayer of MS
Inaholi.
Inamuli, learned state counsel. After
3 weeks.
the 3 weeks, but you have filed your pleadings.
Lordship, these similar matters are pending before the divisional bench.
Hmm?
So Lordship may kindly grant 3 weeks time.
Okay. List the case after 3 weeks.
Lordship, I also beg to mention item number 20 on behalf of Supung Chang. She's waiting for signature, so Lordship may kindly grant 2 weeks time to file counter affidavit.
Hmm? On behalf of,
Supung Chang.
you are for?
I'm for the state.
Okay, respondent. Who is for the petitioner? No name is shown.
Lordship,
Huh?
as long as
You appear for petitioner
Lordship,
in
Lordship.
item 28.
Item 20. 20.
Oh, 20. Okay. MS Asangla,
As long as
S. Kumar, learned counsel for the petitioner is present. MS
on behalf of Supung Chang.
on behalf of Supreme State Council has prayed for and is granted
2
how much
weeks.
time?
2 weeks.
2 weeks time to file counter affidavit.
Lordship,
Okay, to file counter affidavit.
I
It's
pledge.
the case after 2 weeks.
May I please, your Lordship? I beg to mention item number 19. Lordship, we are yet to file affidavit in reply. If 2 weeks' time may be given.
Okay, you are for the petitioner.
Yes, your Lordship.
MS. When affidavit in opposition is filed? You have filed affidavit in opposition,
Yes, your Lordship.
huh? When?
Your Lordship,
Office memo says affidavit in opposition is not filed.
Your
If
Lordship,
the
we already
affidavit in
filed.
opposition is not filed, how can affidavit in reply can be filed?
Your Lordship, we have received the affidavit on 21
Okay. MS,
Conley.
learned counsel for the petitioners has prayed for and is granted how much time?
2 weeks' time.
2
your
weeks
Lordship.
time to file affidavit in reply to the affidavit in opposition filed by the state respondents,
Private respondent, Mr.
private respondent, full stop. MS,
T. Appellate, your Lordship.
T so and so learned counsel for the
Respondent number 2.
respondent number 2 and Mr. K Angami,
For state lordship.
learned state counsel are in attendance.
Obliged, your Lordship.
This is criminal petition. Criminal petition.
Lordship.
What affidavit in opposition and what affidavit in reply?
Lordship, beg to mention item 28. Hearing item. Lordship, by order dated 11/4,
28. Yes.
Lordship, I'm not very comfortable with this order. That the counsel for the petitioner has withdrawn and it has been brought to the notice of the court on 11/7/2022.
11/4/2023.
Yes, that is the last order. But before that,
Who appears for the petition?
Your Lordship, I'm on behalf of my senior, Mr. Gauhati. My senior has already withdrawn his vakalat nama, and to that effect, an affidavit has already been filed.
Lordship, even on
On 25/7, 2022.
Yes,
We said that notice be issued to the petitioner
yes,
through the registry at her address shown in the cost title.
yes.
Whether notice was sent or not. No, huh? Copy is taken. इसका कुछ हुआ है? It is received. Huh? You receive हुआ है क्या? Any idea? This will be sent to the petitioner and directed regarding engagement of the government, which is made ready put up on when it was sent. Registered post. Registered post. That report is not available. Delivery report,
Lordship,
notice was sent
Lordship.
on 24. Oh, only on 24/3/2023. This court ordered on 25/7/2022.
Lordship,
Officers sent the letter by registered post to the petitioner only on 24/3/2023,
okay.
after about 8 months.
Lordship. Lordship, the issue here is by the order dated 11/4/2023. Both the parties,
You are not in a position.
Lordship. So,
What about the petitioner? Okay, we'll just record this. On 25/7/2020, MS
Asikiri.
Asiki, Learned Counsel, appearing on behalf of Mr. Wangarati,
Yangarwati.
has appeared on behalf of Mr. Wangarati and Mr. K. Angami, Learned Public Prosecutor.
Lordship here, senior government advocate.
Okay, Learned Senior Government Advocate are present. Post of this court on 25/7/2022. On 25/7/2022, Mr. Wangarvati, Learned Counsel, who had appeared earlier for the petitioner, had submitted that he had withdrawn his name as the counsel for the petitioner and submitted before the court that he was no longer holding the brief for the petitioner. Full stop. Considering the submission, this court on 25/7/2022 ordered issuance of notice to the petitioner through the registry at her address shown in the cost title in the petition. Full stop. It transfers from the office note dated 27/3/2023 that the notice in reference to the order dated 25/7/2022 had been sent only on 24/3/2023. Full stop. The office to make endeavor for the delivery status of the notice sent to the petitioner by registered post from the postal department, release the case after 1 month. 4 weeks for you, 4 weeks. With the delivery report on
Lordship,
record.
In item number 19, which I mentioned earlier, there is an interim, Lordship.
Okay, interim. Continue for you.
Much obliged.
Yes. There was an adjournment request, right? Kali to mark position.
May I please, your lordship?
There is an
Lordship.
adjournment request.
There was an adjournment request from the respondent.
You are for a petition,
Lordship, I'm for the
Appellant.
appellant,
Mr. B. Devnath.
lordship. However, lordship, on the previous occasion, I had already withdrawn my wakalatnama. It is already intimated to this honorable court, lordship.
No problem is there unless and until a new council is engaged. You are for a
Lordship.
company,
Lordship,
you are for a company.
company, lordship,
So let it remain unless you pursue the company to engage a new council.
lordship,
Otherwise, everybody will come to the court.
lordship.
Mr. B. Devnath, learned counsel for the appellant, has submitted that he has withdrawn his name from the case. Full stop. Be that as it may, full stop. MS,
Petitioner. For respondent number 1, on behalf of B.N. Sharma.
okay. Appearing for Mr. B.N. Sharma. Learned counsel for the respondent.
Yes, respondent number 1.
Respondent number 1 has submitted that a prayer of adjournment to a mentioned memo has already been filed yesterday. And thus prayed for listing of the case after what time?
Can it be listed on 8th, that 8th?
8th of May.
Yes, lordship.
Lordship, I have no objection.
8th of May. List the case accordingly on 8th of May. Praise the Lord for you. You have made more requests.
Yes, your lordship.
Huh?
Yes, your lordship.
Okay. Item number
Item number 3, 13.
13.
Yes, your lordship. And 25.
See, Mr. Devnath, you appear in the case. 13?
Lordship,
Okay, same,
Yes,
13. Order. Then
and 25.
21 already adjourned.
Yes,
And 25 also.
yes, your lordship.
Okay, same. You are for the appellant.
I'm for the appellant.
8th May.
Yes.
8th May, lordship, no. Oblige.
Okay. 3, 13, 25, huh? Yes.
Please, lordship, we have filed a affidavit on 24th April 2023. Your lordship, here the matter is oversensitive. So as of now, we have filed that affidavit, the action step taken by the state respondent in this matter. Your lordship, here, this is, of course, it is the utmost duty of our state to enter and to comply with the direction of the honorable court. The matter is pending since 2019. But the problem here is it is pertaining to two communities. So if the state take any immediate action is taken, then it is something like a operation was successful by patient state. So that will become in duas. Your lordship, here, while complying the honorable court direction, again, if there is any law and order arises in the state, so that problem will become to us, since I'm the constituent of the citizen. So, my lord, I'm praying for more time to comply with the direction of the honorable court. So
Lordship.
everything is explained in my affidavit, but the compliance, my humble submission before lordship, compliance, it will take time. Because it pertains to two communities.
May I please, your lordship. Lordship, may kindly come to order dated 15/12/2022, lordship.
15/12.
5/12/22. 5/12/22, lordship. Lordship, here respond number 1 and respond number 3. They were directed to file compliance report, your lordship. If not filed, then appropriate orders to be passed for personal.
No,
appearance.
what is the compliance report? What kind of compliance report is required?
It is not a compliance report,
No,
Lordship.
no,
Cannot be
no,
construed.
no. What kind of compliance report? Which order? By which order?
Lordship,
Compliance report was asked for.
yes, Lordship, one man inquiry was conducted. Now this court
By
has,
which order? Tell me.
Lordship, by order dated
Just because you,
28/11/18, which is at page
2811,
44, Lordship, in
Huh?
Annexure E. Page 44, Annexure E, Lordship.
page 44 of the
Contempt petition, Your Lordship.
contempt petition.
Operative portions are at paragraph 5, 9, Your Lordship.
Contempt petition. Page 40.
44, Annexure E, Your Lordship.
And
Yeah,
order,
From paragraph, it's
1 minute, let me find out. Affidavit,
page 44.
trustee.
Paragraph 5 would be relevant, Your Lordship, operative part.
Paragraph
5. Eight and 9 also, Your Lordship.
Deep
So, Your Lordship, the inquiry report has given two recommendations, Your Lordship, which is at page 16, Your Lordship.
Okay, where is the cabinet subcommittee? Report,
It's in their affidavit. Your Lordship.
page
Page 33 of their affidavit, Your Lordship.
33. Now tell me. How the chief secretary can comply with condition number 1?
Lordship.
Tell me. As a counsel for the petitioner, how the chief secretary can comply with condition number 1 or recommendation number 1?
Of the inquiry report, Your Lordship.
Okay, cabinet subcommittee report page 32. They have recommended certain measures, right?
Page 32. Lordship.
Page 32. Page 32 of the new affidavit. New affidavit, they have filed on 24th of April.
Yes, Your Lordship.
Page 32.
Page 32.
Starts from page 22,
Okay, Your Lordship.
right?
Yes, Your Lordship.
Annexer B,
Lordship.
cabinet subcommittee report, page 32. Now read recommendation number 1.
Yes, Your Lordship.
Ah.
The Sojung
Now
village.
tell me how the chief secretary can comply with recommendation number 1.
Lordship, this is
In
not.
what way?
This is not a recommendation as directed, Your Lordship. The recommendation of the one inquiry report, Your Lordship.
Huh?
This is not the recommendation which direction was given to comply with, Your Lordship. These recommendations was made by the state government, Your Lordship, on your own, Your Lordship. The inquiry report is page 16, Your Lordship, of the contempt petition, and the recommendations is at page 20, Your Lordship. Two options were given, Your Lordship. Either one or two. Page 20 is the relevant portion in the contempt petition.
Now, what is the direction?
Lordship, the direction.
Recommendation option one, option two.
Option two, yes, Your Lordship. And the petitioners are okay with any of the options, Your Lordship. And Your Lordship, this one inquiry report, no appeal has been filed against this inquiry report also. It is still standing, Your Lordship.
The Chief Secretary and the Home Commissioner
Yes, Your
are
Lordship.
both directed to pass appropriate
Appropriate
order.
steps. Yes, Lordship, appropriate steps.
Appropriate order in
Yes,
terms
Your
of
Lordship.
one inquiry committee.
Yes, Your Lordship.
report.
Now what they are
They,
doing is that,
they have the option of either accepting or not
Yes, Your Lordship.
accepting,
yes, Your Lordship.
right?
Now what they are doing is
Either of
that,
the recommendations.
now what they are doing is that they are taking recommendations from our operators, Your Lordship. The issue is between two tribes, Your Lordship. So
Yes.
they have to do it independently, Your Lordship.
Both the communities are acting independently.
Yes, Your Lordship. So
This is
And
not a
then-
matter which can be,
here, Your Lordship,
which can be complied with by the Chief Secretary alone himself. Now, you want to take you want compliance of paragraph 16,
Lordship.
right? Direction
Yes.
of the contempt petition, paragraph 16, page 42.
Page 42 of the contempt petition, Your Lordship. It's page 45, Your Lordship. The relevant portion is page 44 is the judgment, Your Lordship, and page 45 is the relevant portion.
Oh, which paragraph you are pressing for? Paragraph 16 or 18?
This is not, Lordship, judgment is at page 44, Your Lordship. And
This is your
actually,
contempt petition.
yes, of the contempt petition,
The judgment is what? Which one?
page 44,
Oh, page
WPC
44.
222K of 2018, Your Lordship.
Which paragraph?
Paragraph 5, from 5 onwards, Your Lordship. 5, 6, 7, 8, 9, Your Lordship. If I may allow to read, Your Lordship. 5.
What kind of direction is this? Tell me now. You please interpret this.
Lordship, to the.
One man committee has recommended
Yes, Your Lordship.
two options.
Two options, Your Lordship. Now the
Whether they have tried to implement the first option or not.
no, Your Lordship, they have
No.
not. They have not, Your Lordship.
How can the Chief Secretary force the two communities to live together in peace if they are not in agreement to live in peace together?
Lordship, we just
How
want
can
to,
force? It is a law and order situation. How
Lordship,
can you force?
Lordship, we just want to go back to our homes, Your Lordship,
That
with
is not
security,
possible.
Your Lordship.
That is not possible. Security 24 hours, how can it be possible? If the two communities are at war with each other, how can it be possible? Tell me.
However, there is no
And-
appeal
and-
against the
and you
judgment
pro-
also,
you pro-
Lordship.
give all the monetary support to the state,
No, Your Lordship, but
get PSOs.
Lordship, there is no appeal against the order also, Lordship.
Yes,
judgment.
it is not a positive direction. Take appropriate measures.
Yes, Your Lordship.
Take appropriate measures. Now, what appropriate measures they have taken? They have tried. That is what they have said in the affidavit. Let us read together the affidavit. Latest one. Let us read paragraph 2. Then tell me that what other available option would be before the Chief Secretary and Home Commissioner. Let us read. Making an allegation, it is quite easy. Let us read.
But
From
Lordship,
paragraph 2.
but Lordship, they should also
Let us
understand,
read. When the court directs you to read, you should read.
Lordship, paragraph 2, that at the very outset, the deponent respectfully states and
Okay,
submits
this is leave this one. Then paragraph 3.
that this honorable court by order dated 3/3 has directed the deponent to file appropriate compliance order in terms of the one-man inquiry report dated 9/15, failing which the honorable court may consider personal appearance of the deponent. In this regard, the deponent humbly and respectfully begs to highlight the insurmountable obstacles faced by the deponent in expeditiously giving effect to the one-man inquiry report, despite the clear direction of this honorable court. As the facts presented in the preceding paragraphs will reveal, it is not that the deponent is deliberately and willfully disobeying the honorable court's orders, but the very delicate and sensitive nature of the issue involved in the case requires very careful handling, for even a small misstep is likely to end in tragic consequences.
Okay, read further.
Uh,
Go on.
4, that with a view to bring into bold belief the problems inherent in the one-man inquiry report dated 9/15, the deponent respectfully begs to highlight the recommendations in the report, which reads as follows. 1, the displaced Sumi community of Soyochong village scattered and temporarily sheltered at Kefri town, Soyochong town and Dimapur should provide security protection provided that they prepare to go back to their village. 2, explore ways and means to locate separate Sumi Khel within the village area. 3, separate worship place for Sumi community should be established for free expression in their own dialect during worship without changing village polity, culture, customary law, VDB, village council, etc. 2, a village so wounded by its division, hatreds, and manipulated fears may not have peaceful mind to live together again and survive because they are no longer agree on fact and do not agree their own village history. Certainly don't trust each other's and denial of identity. Hence, best option available is to settle elsewhere and retain certain privilege like avail backward certificate against the name of Soyochong village under Kefri district for limited periods. Allow them have EPIVs against the name of Soyochong village as long as they want the names enroll under 60 AC Soyochong Sitimi. 3, no restriction to use Soyochong village name even though they stay elsewhere. Identify the deserving displaced family living under Kefri and grant immediate cash relief. No restriction to use their properties, either movable or immovable, even if they live elsewhere. At present, there is only one family living in Supply Godown at Soyochong town. Another 5 families were living in PWT PHE vacant quarters. 9 families were living at Kefri town. In case
How many Sumi families?
there are about, by the latest report, there are about 30 something, Your Lordship.
Huh? This report, one-man committee says 5.
It was the,
Nine.
in the affidavit filed by
14.
the government only, Your Lordship. After verifying. Your Lordship.
Now, second recommendation itself says that
Yes, so
the village is so wounded by its division, hatred.
we are fine with the
fears.
second option also, Lordship. At least one
So,
option. We are, if
It
they
is
can't do the
quite
first
clear-
option,
It is quite clear that there is hatred between the two communities.
so Lordship, we are fine with the second option. The 1, 2, 3,
Okay,
4,
let
5.
us see then what the.
So if they can't do the first option, second
Because
is okay.
whether
with
there
us.
is deliberate and willful violation, contempt is deliberate or
Yes, Your
willful
Lordship.
violation.
Yes,
If
Lordship.
one cannot be done,
Lordship,
possibly, then there cannot be willful violation,
Lordship,
right?
Lordship.
Deliberate violation. If one has made the effort to comply, if he has made sincere efforts, then there cannot be any willful violation or deliberate violation. So contempt application is that. Not only compliance. Compliance, if the compliance is not made deliberately and willfully,
Lordship, since they were
let
not,
us proceed.
Lordship, since
Let us proceed. Whether willful or deliberate violation on the part of the chief secretary, you are calling for personal appearance. So let us go and find out.
Lordship, that the aforesaid recommendation of the one-man inquiry report was seriously considered and efforts made to give effect to one or the other option in the recommendation. But neither of the two options were attainable for the fact that both the parties continue to stick to the resolved position and emotions continue to run high unabatedly despite the passage of considerable time. Hence, the deponent begged to respectfully state that no matter what the level of advancement towards a modern way of life, Nagaland remains essentially a land of tribes and villages where ancient customs and traditions are regarded by the people as higher than any other laws in existence. And one thing the Nagas are not for is the fierceness with which they react to protect their customs and practices. In this regard, at times, the situation become violent as history is witness. In view of the Naga community trying to protect what they perceive is sacrosanct and the very essence of their tribal identity. Even at this day and age, the villages assert their independence as God-given right, no matter how ill-conceived, and the administration is compelled to maintain a delicate balance while negotiating this minefield on daily basis in order that peaceful existence is maintained, as is highlighted in the report. The two communities have been living side by side as though it were one tribe village since the founding of the village in accordance with the customary laws. When the Sumi tribesmen of the village sought to undo the status quo by asserting their constitutionally recognized right to have their own separate church and social organization in the village, for the sanctum tribesmen of the village, it was as if perceived not only betrayal for up their trust, but a trampling of their sacred customary laws, an unforgivable transgression, no matter how unreasonable it may appear to an object observer. For the sanctums of the village, since the Sumi villagers voluntarily deserted to the village as per traditional custom, they cannot return to the village. As is also reflected in the inquiry report, it is their unflinching stand that the Sumi villagers have been staying in the village with their permission from the very beginning, from formal customary adoption as sons of the sanctums. Whereas both the recommendation of the inquiry report entails protection of the Sumi villagers' assertion to maintain their own tribal identity while still continuing to stay in the village or in the village land, which is anathema to the sanctum villagers. Under such circumstances, any action by the administration compelling the sanctum villagers to accept the Sumi villagers by the use of state force after recognizing their assertions to maintain their identity. It is in the matter of either of the two recommendations would be perilous act that may have disturbing result with the likelihood of wider conflagrations involving the two tribes. That it is respectfully stated that considering the delicate and highly sensitive nature of the issue involved, the government constituted the cabinet subcommittee and the committee having conducted hearings and collected extensive relevant data submitted report dated 14/10/2020 with the following recommendations. The Sejong village should allow for resettlement of the displaced Sumis. Now it is their recommendations, the government recommendations. Yes, Your
What is the order,
Yes,
Miss?
Your Lordship.
Firstly, let us see the order in the contempt petition. What? Paragraph 5, one-man committee had
Yes, Your
already
Lordship.
submitted its report. It was to be acted upon by the
Yes, Your
authority
Lordship. Yes, Your
and
Lordship.
pass appropriate order on the
Lordship.
basis of the findings and recommendations made therein.
Lordship.
So acted on
Yes.
the reports and constituted a subcommittee. It was to be acted upon by the authorities because he has not said, he has recommended.
Yes, Your Lordship.
Then pros and cons are to be examined.
Lordship.
So government has acted on the report and constituted a subcommittee.
Lordship.
It is not that the one-man committee report is the sacrosanct. It has to be acted upon.
Lordship, I agree, Your Lordship.
Then it has proceeded.
This,
Let us read,
Lordship, the Sejong Village Council should allow for resettlement.
because all these recommendations are ifs and buts. Ifs and buts. If this is not happening, please try to do
Lordship,
this.
I-
If that is
if
not
I may-
happening, please try to do this.
If I
This is
may,
not a clear recommendation that he is to be appointed. No, not like that. Between two communities, there are separate beliefs, they are at war, they are at hatred, there is no peaceful coexistence. So one cannot go and simply say that you, from tomorrow, we live in peace. Then whether 24 hours protection can be given to them. Any of two neighbors,
Lordship, Lordship.
see your case, suppose you are at war with your neighbors. Can the state 24 hours provide protection to you? Question is how the best, the
Yes, Your
solution
Lordship.
can
Yes,
be
Your Lordship.
evolved. That is what one should try. Just because the contempt application is about willful and deliberate violation,
Lordship.
not violation, simpliciter.
Lordship,
Be mindful of that.
Lordship. Lordship, if I
And
may,
chief secretary is the highest authority in the state.
Lordship.
To bring allegation about willful violation on his part, let us see what he has done, what he has tried to do.
Lordship. Now, Lordship, let's
Read
direct up
paragraph
to
6.
4 and 5, 6, Lordship.
Let us, paragraph 6.
Yes, Your Lordship.
Let us read.
Failure to comply with the above recommendation may
Should
lead.
follow Session Village Council. Now, Session Village Council is a statutory body. Is it not? Under the Village Council Act.
Yes, Your Lordship.
Now, recommendation was made that Session Village Council should allow. Now, Chief Secretary cannot force them.
Lordship.
Is he in a position to force them? Or allow for settlement of displaced Sumis without any precondition? That has been denied by them.
Lordship.
Council denied.
Yes, Your Lordship.
No precondition. We will not allow. That is what they have done. Is it not?
Lordship.
Then read paragraph 2, second recommendation.
As per available evidences, that is documents submitted and the physical appearance presence, it is clear that the Sumis arrived at Suyuchong village some years after the Sanctums established the village. Hence, the Sumis should not claim co-foundership of Suyuchong village and should refrain from demanding separate village or khel within the village jurisdiction, but peacefully coexist in the village as it has been from their forefathers.
Sumis are not agreeable to this,
Yes, Your Lordship.
right?
Yes, Your Lordship.
Recommendation
No.
number 1 is not agreeable by the Sanctum.
Yes, Your Lordship.
Then recommendation number 2 is not agreeable by the Sumis.
Yes, Your Lordship.
Then come to 3.
The district administration should conduct verification of household or properties of the displaced Sumis at Suyuchong village and also conduct verification drive along the line department for re-enumerating the displaced Sumis of Suyuchong village in Dev.
This can be done.
Not done yet, Your Lordship.
Now, this can be done.
Yes,
Let us,
this can be done, Your
this
Lordship.
can, let us, that is
Yes,
why
Your
we are hearing you.
This can be done, Your Lordship.
That is why we are hearing you.
Yes, Your Lordship. For Your
You
Lordship.
cannot say that all this.
Yes, Your Lordship. Agree, Your Lordship. Now, 4. After the resettlement of the displaced Sumis, Jum cultivation should be allowed to the displaced Sumis of Suyuchong in all those areas, location where they have been undertaking
This
agriculture.
appears
Is
to be
this
not possible. Resettlement in that village,
their home, Your Lordship?
that is not
Their
possible.
ancestral home, Your Lordship,
That
where
is
they have
not
been doing
possible.
agricultural activities. Your
So,
Lordship.
Mr. Council, why don't you find out separate places for their settlement?
Your Lordship, here, as per the recommendation, option 2, clause 1 and 2 is already complied. Regarding the backward certificate, then the arrangement is made in such a way that,
This recommend, no,
yeah, okay,
in your affidavit, this cabinet subcommittee has made some recommendations.
yes,
1 and 2 appears to be not possible. 3rd is possible. Page 8.
yes,
Now, after the resettlement of the displaced Sumis, meaning thereby the Sumis are to be resettled in the original village. That is not possible because there will be again
yes,
ethnic
yes, definitely.
disturbance. Then
Your
5,
Lordship,
recommendation 5. Process of resettlement should not be completed. If 4 is not possible, 5 is not possible.
so, Your Lordship, here, in order
Let
to,
us find out the
Yes, yes.
solution.
yes, so we need more time,
No, what kind of solution? Let us also find out.
yes.
Then paragraph 7. See paragraph 7. What they have done.
7.
Both the parties refused to accept the aforesaid recommendation of the cabinet subcommittee.
Lordship,
And the tendency was that any move to give effect to the same would result in serious law and order problem. Therefore, cabinet subcommittee reconvened, visited the village also on 7/5. Separate meetings with the 2 parties. Now what the Sanctum says, the response was not agreeable to welcome back the moved out Sumi household. After thorough deliberation discussion, the village council assured to consult the matter with the general public of the village, who will intimate the government. On the response of the Sumi villagers of the meeting, the displaced Sumi said they are willing to go back, but reiterated they should be allowed to have their own place of worship. SARS, that is not allowed by the Sanctum. SARS is not allowed by the Sanctum. Subsequently, on so-and-so cabinet subcommittee having received a written response from the so-and-so dated so-and-so convened meeting and the minute of it. Okay, examine the matter in response to the government. Not to allow the request to be released. So let us make you the mediator. Will it be possible for you to come up with a solution with the two tribes?
No, Your Lordship.
Tell me. If you are in a position, we'll remove the chief secretary. No, you don't meddle into their affairs. You be appointed.
No, Your Lordship.
Hmm,
We can't do
Possible?
that, Your Lordship.
If two parties have started a war, if it is not possible for a mediate, what to do? If it is not possible for the Sumis to go back, now whether these Sumis are agreeable to their settlement in separate piece of land, because it appears it is not possible for the Sumis to go back and live peacefully. There will be killings.
Yes, Your Lordship. Then exactly. Your
Now
Lordship.
find out, now tell me the solution also.
Lordship,
Your role is not to only create the problem, also to give solutions.
that's why, Lordship, we are okay with the
Give
second
solution,
option.
some kind of solution which can be worked upon by the state council.
Lordship, we are okay with the second recommendation of the
Let
incumbent.
us see the
Lordship.
second, and once again,
There, we don't have to go back to the village, but at least we should be given
let us
some,
see the second option, page
page 20, Your Lordship.
20. Your option elsewhere, find out.
Yes, Your Lordship.
Yeah,
This will go on, this will go on,
Yes.
this will go on. Chief Secretary himself has said, I am helpless. Now, whether the second option can be
Yes.
explored,
Second option, clause 1 and 2 is already done by the state.
no.
No, Your Lordship.
Best option available is to settle down elsewhere.
And retain.
He is a
certain-
chief secretary, he can find land where they can be settled.
That will be another problem. That will be another problem for the state also,
Right?
but it will take time. So
What
by giving the sufficient time, the state has to find out the.
How many
voice
Sumis? What is the total number? Nobody has said
Yes.
50, 100, 1,000, 150, 200. Nobody is saying. How many have been displaced?
Yes,
Have you got the number or number of families?
yes, I'm not aware.
Nobody is saying. Be practical. Suppose if there are, see, chief secretary, what chief secretary, no, somewhere I have seen,
Yes,
cabinet subcommittee, whatever. Come to your affidavit. Your affidavit, page 21. See 6, 7. At present, there is only one family living in Supply Gudam in Seochong, and another 5 families were living in PWD vacant quarters, meaning there were 6 families. Then 7, 9 families were living in Kipre town. If that is so, then only 15 families. If that is correct,
yes.
then 15 families. 15 families are to be resettled. How big a village in Nagaland? Average? I am not conversant. Tell me.
In the previous affidavit, Your Lordship, government's affidavit, they have, if Lordship is there, Your Lordship.
Tell me. Tell me.
About-
How many families?
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12. There are about 39 households, Your Lordship. 39 households.
39 households,
Yes, Your Lordship. It's not
39
much, Your
households.
Lordship.
according to petitioner.
Lordship, here, the landholding system in Nagaland is very unique. So government has no, its own land. Because all it is occupied by individual clan and village. But your Lordship here,
Maybe wasteland is there or otherwise
No,
you
no.
acquire.
unless it is acquired by the
You
state,
acquire.
unless it is acquired by the
Acquired.
state, then there is no government land. And your
Because-
Lordship here, it is, this contempt cannot be agreed with other contempt petition. This contempt is very peculiar contempt, we pertain to two communities. So why it takes only time? Because there is a crack in the human mind. So there is no authority on earth to mingle the cracked human mind. It is a divine intervention.
Right. So,
At the
I'm-
most is time. Only the time will.
Time, how many decade? It is so deep-rooted, the faith is so deep-rooted. I don't think time is the healer here. Time will be a healing factor.
Why, Your Lordship, if I take a hasty decision again,
No,
under.
no, I'm not saying that. No, why don't you explore the second option? About resettlement elsewhere.
Yes, second option, we can go, partly we have done, and next part, Your Lordship, I have to get more instruction from the state also. And
Definitely.
our state also, we are, again, even on the 19th December last year, Cabinet subcommittee, they have a meeting. And again, because of the changing of the government, now it is stopped, and government is, I think, willing to continue this,
But
to take up this issue.
considering the averments made,
Yes.
tell me of the record. Would it be possible in a near future for the Subis to go back to their village?
No, I don't think.
Of the record, be fair to the court.
Yes,
It is not possible.
not possible.
So this discussion will go
Yes,
waste.
yes.
So be practical. So why don't you explore the second option of the page 20,
22.
one-man inquiry committee, second option. See the second, a village so wounded by its division,
Yes.
hatred, manipulated fears, may not have peaceful mind to live together again and survive. Because they no longer agree on the fact and don't agree. Their own villages, certainly don't trust each other. So there is complete trust deficit
Yes,
and denial of identity. Hence, best option available is to settle down elsewhere. So that is the only option now. Why don't you explore that? MS Esther, there is no willful kind of violation or deliberate kind of violation. Let us keep it pending, try to get the best possible solution. Merely making allegation that violation will not do, because there is no clear direction also by this court. Appropriate order. Appropriate order means anything. It may be denial also. Then again repetition. Have you got my point?
No, Chief.
Appropriate order doesn't mean that positive order. It could be negative order. If it is negative order, then again you have to pursue repetition.
yes.
You have to file repetition again. So, Mr. Counsel, state.
Your Lordship, I'll take an instruction. Your Lordship may give a direction.
MS
Esther, Your
Esther, Learned Counsel for the petitioner.
Lordship may also consider since 2008. Since 2008, the petitioners have been rendered homeless, Your Lordship. They are scattered elsewhere. Some are still staying in a godown, Your Lordship, which
You
which
would like to respond to this?
this is not reply, Your Lordship.
Huh? Okay, anyway. Has
Yes, Your Lordship.
submitted that
Yes, Your
as per her knowledge, there are about 39
39.
Sufi
39
households
Yes, Your Lordship.
originally in the village. What
Scattered-
village? What is the name of the village?
Scattered everywhere, Your Lordship.
See
They are scattered, Your Lordship.
you, Chong village.
Huh?
The Sumis of Seochong village, Your
No,
Lordship,
No,
scattered.
the village. What is the name of the village?
Seochong village,
See
Your
Chong
Lordship.
village.
Has submitted that after their displacement, from Seochong village. As far back as in the year
2008.
2008, comma, the Sumi, displaced Sumis
Lordship.
are staying at different places, including in supply Godam,
Yes, Your Lordship.
comma, PWD stroke PHED vacant quarters, or in some other towns,
Yes, Your Lordship.
and they have not been able to go back to their original place of residence, i.e. Seochong village till date. Full stop. MS Esther has also drawn attention to the second option made by the one-man inquiry made in the report of the one-man inquiry. Full stop. The report of the one-man inquiry contains two recommendations, two alternative options, Page 20, first option, second option, page 20, A to A. The affidavit filed by the respondent number 1 in reference to the order dated 33/2023 has indicated has also made mention of the two alternative options recommended by the one-man inquiry committee. Full stop. The said affidavit includes has reported about the steps purportedly taken by the administration with regard to the first option. Full stop. MS Esther has submitted that though the steps taken are not enough and have left much than the expectation, there appears to be no purported steps on the part of the administration to explore the second option. No purported there appears to be no steps taken by the administration to explore the second option which requires settlement of the displaced sumis, physical settlement of the displaced sumis anywhere or somewhere else. Close to. Mr.
in terms of additional age.
Additional Advocate General has submitted that we will obtain instruction as regards the further steps taken as by the administration as regards the first option and as to whether the administration can settle the displaced sumis at any other suitable lands at the earliest. Let us see, because there will be killing. It appears, I don't know. You will better know, but from the Chief Secretary's affidavit, they are at war. So let us be practical. If there is some land nearby where they can be settled, and some will think of economic help also.
We are
If-
okay with the second option. also, Lordship. That's what we have.
If
been
there
saying
are
all the time.
schemes, government schemes for construction of houses, then these schemes should be given to them. Ultimately, they are residents of the state only. Maybe different communities, maybe minorities, but they should be protected also. Okay, how much time you require? Both the option. You continue with the first option,
Yes.
but explore the second option also. Am I clear? Am I clear?
Yes, I'm clear.
You continue with the first option,
4 weeks,
but also explore the second option.
definitely.
Try to find out land.
Yes.
Shall I give more? The response number 1 shall apprise this court about the availability of suitable land at the disposal of the state for settlement of the displaced sumis.
Yes.
Let us find out. Let him respond.
Lordship.
In which district?
Kifri District.
District Kifire. In district Kifire. Let us find out
Lordship.
if it is Kifire, some land is available at the disposal of the government. We'll find out, or otherwise you
Or
can
any district, Your Lordship, we are not
Huh?
aware. District also anywhere, anywhere.
any district
Anywhere.
or any other district. District Kifire or any other district. List the case on
After 4 weeks,
choose a date. Fifth of June,
that will be too early.
4 weeks. You have said 4 weeks.
Yes.
5th of June,
For middle of the June.
12th June,
Most of
12/6.
What about the consensus prayer of all the parties, Lordship? If this matter can be taken up on Thursday, Lordship, subject to convenience of this honorable
Not
court,
Thursday, Mr. Jamir,
Lordship,
someday else.
Lordship.
This is what?
This is for posthumous regularization, Lordship.
Is the issue pending before Supreme Court?
No, Lordship, that has been disposed, Lordship.
What is the order passed?
Lordship, it was, on order was a judgment in personam, Lordship, on the ground that the petitioner in that case, Lordship, he has approached the authorities after a period of 12 years, Lordship. So the division bench judgment and order was questioned, Lordship. That was indiffered, Lordship.
Division bench ordered what?
Division bench,
Single bench ordered what?
single bench has given relief to the petitioner,
Ah.
given a direction to the state to consider.
Ah.
That was upheld by the division bench, Lordship.
Okay. Then
Honorable Apex Court has stated that, Lordship.
initially stayed.
Lordship.
Thereafter,
Lordship, delay of 12 years,
so set aside,
set aside, Lordship.
set aside.
Lordship.
The facts, whether this, it is where, how much time?
Lordship, factually it is similar with this case,
Then
Lordship. Lordship.
RAM may be issue, but the facts are similar.
Lordship.
Okay, on the prayer of Mr. Mohan Jamil and the counsel for the petitioner, at least the case in the next week.
Lordship. My apologies.
Yes.
May I plead the lordship? Lordship, this is an appeal against the impugned judgment and award dated 27/8/2019, passed by the learned tribunal Moksha. In respect of the alleged road traffic accident.
It will be
Took
taken
place
up
on-
in admission or what? Appeal is admitted.
Appeal is
Not yet
admitted.
Appeal is
Admit.
admitted on 6/4.
6/4/2022. 6/4/2022.
Ah. It is to be listed for admission column or hearing column?
For hearing column, Lordship.
What is the issue here?
Lordship, the issue is.
Accident not denied. Accident denied or not denied?
Accident denied, Lordship,
Accident denied.
denied.
Not denied, Lordship.
And the claimant
It has been
exhibited the
proved.
policies.
On what ground it is denied?
Lordship, the claimant in his claim petition, in her claim petition has stated that her son was a pedestrian. And in her cross, she said that while loading the logs, he was hit by a vehicle. And as per her statement, the accident took place at 10:30 AM. However, the GD entry, purported GD entry shows that the accident, the GD entry opened on 8 AM on the said date.
She was not a witness,
She was not a witness.
eyewitness,
She was not an eyewitness.
hearsay,
Yes. So that is not.
but
admissible.
whether accident happened or not. That is hearsay. The date is clear. On that day, accident happened.
Yes.
She said that 10:30.
But Lordship,
But she was not an eyewitness, so she was a hearsay witness.
Lordship,
Now, what is to be believed? If there is a report, the report will prevail over the hearsay evidence.
Lordship,
Then what other issues?
Lordship, the next issue is that the insurance policy exhibited by the claimant is a fake policy.
Fake.
Lordship, it is not been issued by the concerned office, Lordship.
Lordship, this was not an issue before the tribunal.
When did you raise, was it
Lordship,
an issue?
Lordship, there was the officer of the company was has deposed his statement as well as in his cross. It is stated that the policy, it is not issued by the insurance company, Lordship.
Mayor statement will do.
No evidence.
Lordship,
only,
to that effect,
nothing was
Lordship, there was
shown
an FIR lodged
to prove that
in
the
the concerned police station.
policy was fact.
Before whom you have lodged the complaint?
Lordship, before the officer in charge, Tuli Mokchung, Nagaland.
What is the delivery status? You have sent it by post only. You have not gone there physically to lodge the affair. So you have sent it by post. What is the delivery status? Police was exhibited.
Lordship, policy was exhibited.
Is there any person by the name of Otri Chakraborty?
Lordship, in the policy, yes.
Is
But
there
then-
any officer in your by name of Otri Chakraborty?
He was an officer of the concerned insurance company, but as to the information I gathered from the company, on the date of issuance, he was not serving as the concerned officer in that office from where the policy was issued. That is Gauhati.
He will not be. Because he is the national head. He is not, will not be working in Gauhati. He is the national head operation. He'll be working in Bombay or Delhi.
Lordship, my apology, I'm the DW2 I'm talking about. The
His evidence is nothing. It goes nowhere. Sending a complaint by registered post. Not even an FIR. Prima facie, this appears to be a genuine one. How to rebut this evidence?
Lordship,
Tell me,
Lordship,
in what way you can rebut these two?
Lordship. Lordship,
Lordship, you have admitted in the written statement.
Huh?
In the written statement, you have admitted to all the documents that has been annexed with the claim petition.
Is it so?
Yes, Lord. Para 4 की written statement.
Paragraph 4.
And Lordship, interestingly,
Recent
para-
driving insurance policy annexure 3. Annexure 3. Are not denied. Insurance policy is not denied.
Lordship, interestingly, at para 9 also, while during this appeal stage.
Para
Yeah.
9.
Yes.
Para
we
9
are
of which
saying that the para 9 of the same, Lordship.
written statement.
Yes, written statement.
There is no para 9.
In mine, yes. That's
Oh,
a,
no, no. 1 minute. I'm
It-
sorry. Para. Their affidavit,
para 9,
para.
para 9 of the.
No, regarding admission of the insurance policy.
Lordship, in one hand, you are saying that the policy is a bogus policy, but in one hand, on the other hand.
Where,
you are
where
referring to
the-
the-
Lordship, para 9 of the
Buying in
WS.
contravention. Para 6.
Lordship.
Para 6 of your written statement. Please read. Driver so and so vehicle was buying in contravention to the provisions of insurance policy at the time of accident and have not satisfied the requirement of rule number 3 of the Central Motor Vehicle Rules 1988. It should be 1989. In as much as alleged driver was not possessing any valid and effective driving license. That is the stand you have taken. Then where insurance policy is denied in which paragraph? Which paragraph?
Lordship, I'm referring to para 9
Para 9.
of the WS. At page 4. In one hand, they are denying, in the other hand, they are.
No, they are not denying. They are saying only contravention of the policy.
That's why.
Paragraph 6,
If
contravention
they-
of the
They
policy.
are saying that the policy is a bogus policy.
No, where they have said,
Lordship, in the present appeal, they are saying that this.
huh?
In the present appeal, they are saying that the policy is a bogus policy. That's the only ground. Lordship, the other ground that, may I?
Any other ground?
Lordship, hold on, huh? No, Lordship.
Okay, firstly, yeah, have you cross-examined these two witnesses? And any suggestion was given that the insurance policy was fake?
No, Lordship.
Huh?
No, Lordship.
No. Then what the investigator says? My name is Papan. Who was DW1
Lordship,
owner?
DW1 is the owner of the.
Owner.
Owner.
Owner, he has come on his own or on at your instance?
Lordship. On his owner.
Huh?
The owner filed the affidavit. On his own, the tribunal.
He has filed his own.
Yes. More so, Lordship, before filing the MSC case, before the tribunal, learned tribunal.
Ah.
The owner as well as the deceased family members, they have already compromised the matter before the officer in charge of the concerned police station, Lordship.
It normally happens.
This is not an issue before the tribunal.
Now he says my vehicle has all the valid license and all valid insurance policy. So, and I have done my insurance from registered Gauhati office. I have done this insurance through my friend.
Through my
I can-
friend.
I can able to produce the original insurance policy before the tribunal. And then when the court, I have brought original insurance policy exhibit P3.
Lordship,
P3 exhibit, he exhibited the policy.
Lordship.
Now, anything else?
Lordship, in that eventuality, Lordship, if I may be given some time to Lordship, my small prayer, that to have a discussion with the company regarding this policy matters. A small time, Lordship, a week or so.
I have proceeded with that.
Lordship,
I have proceeded on the premise that this is for disposal.
Lordship, it can be disposed of. Lordship, firstly, the insurance company has not taken the permission under 170B.
No, rebuttal evidence is doubtful. This
Lordship,
Kamaljit,
it will be
Kamaljit or Kamaljit, whatever.
the claimants, they are suffering, Lordship.
What more is required?
Apart from the loss of their son,
What more is required? Tell me.
Lordship,
What instruction?
sometime, Lordship.
No, what instruction?
Lordship, regarding that policy, Lordship.
You have denied
Yes, we have.
by DW2. The point involved.
Lordship, here the accident occurred and the vehicle which was involved in the accident, it did not have the permit to ply the vehicle on a particular place. And
Is a third party?
third party.
If it is
And-
required, permit, whether violation of the permit
Lordship,
is on the part of the owner or a pedestrian or third party.
part of the
Fault
owner,
lies on the owner.
part of the owner.
Now, what the precedent says, authority says, Supreme
Lordship,
Court decision,
Lordship, yes.
permit violation,
Lordship, 2018, 7 SCC
Uh-huh.
558, Lordship.
what does it say?
Lordship,
Permit violation.
Lordship, first of all, Lordship, the MV Act, Lordship. May
No,
I-
the permit, what does the authority says? Third party is to be given or not given?
Lordship, Lordship, it is section 231, 66(1) and 149 to
Motor
route
vehicle.
permit and permit.
Huh?
Section 231. Section 2 clause 31,
Hmm.
section 66 clause 1 and 149(2). Route permit and permit. Distinction explained.
Permit.
Lordship,
It is to be issued by a regional transport authority.
Lordship.
I think it is section 68 perhaps,
66,
66 or 68.
66
66.
clause 1. Lordship.
Ah. Now, suppose it is, this condition is violated by the owner,
Lordship,
but the vehicle is otherwise insured.
Lordship,
Now, the person who has claimed compensation is a third party.
Lordship.
Now, what will be the law? Pay and recover or what?
Lordship, pay and recover.
That's all. Yes,
Lordship,
any authority, pay and recover?
no, Lordship, actually, Lordship, before the London Tribunal, the insurance company, they have failed to even produce their witnesses to contradict with the statement given by the claimant.
Now tell me, what is the authority of on pay and recover?
The discretion of the Lordship, that is.
There are so many judgments. Okay, I'll find out one. I forgot it now. Heard Mr. B. Devnath,
Lordship, V.
P. B. Devnath, learned counsel for the appellant.
May I please your lordship? I'm representing respondent number 5, that is vehicle owner. So I have a small submission to be made before your lordship. So in respect of issue number 4, that is of the permit, the appellant never produced the evidence before the honorable court tribunal. So now they can't see that because they never bring the evidence. And then there is a case, decided case.
Whether they have brought evidence?
No, your lordship.
No
There's
defense
no,
witness?
no
defense
evidence was
witness?
produced.
Huh?
No evidence was produced by the appellant before the tribunal. And there is a decision given by Chhattisgarh High Court. I could not find the book, so I'm just.
Okay, before the tribunal,
Lordship.
what are the evidence? Supported claimant number 1. Okay. Mr. Who is for the claimant? Mr.
Selina Dutta for Tayong Chuba.
Your name please? Rayang Chuba,
Lordship.
learned counsel for the. Please take your seat then. 1, 2, 3.
1 to 3, Your Lordship.
And MS.
Mua Chung La for respondent number 5.
Learned counsel for the respondent number 5. What about 4?
Your Lordship, respondent
By
forms.
order dated 8/8/2022, the service of notice upon the respondent number 4 is deemed to be served. Full stop. This appeal under section 173. Motor Vehicle Act is directed against the judgment and award dated 30/1/2020 passed by the learned member Motor Accident Claims Tribunal, Dimapur. Within bracket, the tribunal for short. In MSC case number 54/2014. Full stop. By the judgment and award dated 30/01/2020, the learned tribunal has awarded an amount of rupees 7,70,000 including rupees 50,000 towards no-fault liability, as compensation to the three claimants, comma, who are the respondent number 1 to 3 in the instant appeal. Full stop. There are. The claimants, the respondent number, sorry, the claimants, that's respondent number 1 to 3 are the legal representatives of one Junathan. Full stop. In the claim application instituted under section 166 of the Motor Vehicles Act 1988, comma, the claimants had projected that the disease on 23/8/2013, comma, the disease, comma, Junadhan was proceeding as a pedestrian and at that point of time, comma, a vehicle bearing registration number NL-07/A-4677 proceeding in a rash and negligent manner, comma, knockdown Junadhan. So as a result of the accident, comma, Junadhan met instantaneous death at the spot. On receipt of the claim application, comma, the same was registered and numbered as MSC case number 54/2014. Full stop. Upon such registration, comma, the learned tribunal by order dated 19/3/2014 issued notices to the owner of the within bracket the NL so and so within bracket the subject vehicle for sold to the owner, comma, the driver and the insurer of the subject vehicle. Full stop. On receipt of notices, comma, the driver, owner and the driver of the subject vehicle had submitted They appear, Mr. Debnath?
Lordship. Owner and driver, they did not appear.
You filed a joint written statement or what? Or separate?
Separate, your lordship.
Not available? A joint written statement as opposite party number 1 and opposite party number 2. Full stop. The insured as the opposite party number 3 had also filed its written statement. Full stop. Based on the pleadings of the parties, comma, the learned tribunal had framed page 69 as here. Had framed following 5 issues. Page 69. Paragraph. In the course of the proceedings, comma, the claimants examined two witnesses, that is PW1 : Srimati Silina Dhon, SILINA Dhon. The claimant number 1. That's respondent number 1. And Roman 2. Roman 2, then PW2, Ranjit Orang. First of PW1 was the wife of the deceased, and PW2 deposed as an eyewitness to the accident. Full stop. PW1 exhibited 9 number of documents. Exhibit P1, claim application. Exhibit 2, not like exhibit, not 9. Following documents. Exhibit P1, claim application. Exhibit P3, police report. Exhibit P4, registration certificate. Exhibit P5, insurance policy. Exhibit P6, MBI report. Exhibit P7, requisition of police case number 110/13. This. And exhibit P9, post-mortem examination report. The Opposite parties did not adduce any evidence. Full stop. After closure of evidence, comma, the learned tribunal, after appreciation of the evidence on record, comma, decided all the issues in the affirmative. Full stop. Insofar as the issue number 5 is concerned, comma, the tribunal, the learned tribunal accepted the age of the deceased as 45 years at the time of the accident, comma, on the basis of the age recorded in the post-mortem examination report and in the absence of any evidence in rebuttal. Full stop. Though the claimant side had deposed that the tribunal accepted the age of the, sorry, the income of the deceased, monthly income of the deceased as rupees 5,000 and comma dash comma the annual income as rupees 60,000. Full stop. Adding 25% as future prospects, comma, the learned tribunal had arrived at the figure of rupees 75,000 and using a multiplier 14, comma, the tribunal assessed the total pecuniary loss at rupees 10,50,000. Full stop. Deducting 1/3 of rupees 10,50,000 towards personal expenditure, considering the fact that the deceased had left his wife and 2 minor children. Full stop. Don't know like a comma. The tribunal calculated the total the compensation amount at rupees 7 lakh. Full stop. By addition of rupees 50,000 towards funeral expenses, comma, 15,000 towards loss of estate, and 40,000 towards loss of compensation, comma, the tribunal assess the total compensation at rupees 7 lakh 70,000. By deduction of rupees 50,000 paid towards no fault liability earlier, comma, the tribunal directed the opposite party insurer, i.e. the appellant herein, to pay an amount of rupees 7 lakh 20,000 to the claimants with interest at the rate of 9% per annum on the said amount from the date of filing of the claim application till the date of full satisfaction of the award. Full stop. Where I agree thereby, comma, the appellant insurer has preferred this appeal. Full stop. Yes, what was the ground you urged? I forgot.
Lordship,
Just which we discussed, what was the ground? Permit.
permit.
Did you take that plea in the written statement?
Not specifically.
Hmm?
Not specifically.
What is the nature of the vehicle?
Lordship, it is
Mr.
a,
Devnath, learned counsel for
carriage
appellant has
vehicle.
submitted that
it is a carriage vehicle, goods carriage.
the
vehicle.
subject vehicle was a goods carriage vehicle. And the accident occurred at which place?
At Jafrajan.
Where from we can find? At a place under Bukajan police station.
Lordship.
And in connection with the accident, comma, a police case being Bukajan police station, case number 110/2013 was registered for offences under sections 279, 304 A/427 IPC. Full stop. It is his submission that at the time of at the time and date of the accident, comma, that is, comma, at 12:30 AM on 23/8/2013, comma, the subject vehicle did not have the necessary permit to proceed on the proceed by the road where it made the accident. Full stop. Well, and as such, the insurance, the vehicle, subject vehicle was plied in contravention of the terms and conditions of the insurance policy. Full stop. He has further contended that when the investigator deputed for the purpose, met the father of the opposite, father of the owner of the subject vehicle, he revealed that the subject vehicle was purchased by him and got it registered in the name of his son, i.e. the opposite party number 2. Full stop. The father of the opposite party number 2 had denied that the subject vehicle was ever involved in any accident at around 12:30 p.m. on 23/2013 near Zaporizhzhia IB on National Highway number 39, Karbi Anglong. Full stop. Projecting so, Mr. Devnath has submitted that the insurance company, appellant insurer is not liable to pay any compensation. Full stop. Para 2. It is contended on behalf of the appellant insurer that the father of the opposite party number 2 had denied involvement of the subject vehicle in any kind of accident at 12:30 p.m. on 23/2013 on the National Highway number 39 near Zaporizhzhia IB, causing instantaneous death to the deceased, the accident information report issued by the officer in charge, Bukazan Police Station, exhibited as Exhibit P3, has stated about the involvement of the subject vehicle in an accident occurred at 12:30 p.m. on 23/2013, and the registration of a case, Bukazan Police Station case number 110/2013 for the under sections 279, 304 A 427, IPC. Full stop. The accident information report within bracket Exhibit 3 issued under section 158 within bracket 6 of the Motor Vehicles Act has also mentioned about the death of the deceased Junad Hon. Full stop. The father of the opposite party number 2, who had denied involvement of the accident, did not enter the witness box to say so. Full stop. The fact that the subject vehicle was involved in the accident in question resulting in the death of the deceased is further fortified by the fact that the investigating officer of Bukajan Police Station case number 110/2013. After completion of investigation, had submitted a search sheet with search sheet number 5/2014, dated 28/2/2014. Against the opposite party number two. Correct. Insofar as the issue of route permit is concerned, it is true that section 66 of the Motor Vehicles Act 1988 has prescribed about the necessity of a permit to stop. As per section 66 of the Motor Vehicles Act, no owner of a motor vehicle shall use or permit the use of a vehicle as a transport vehicle in any public place, whether or not such vehicle is actually carrying any passengers or goods, save in accordance with the conditions of a permit granted or countersigned by a regional or state transport authority or any prescribed authority, authorizing him of the use of the vehicle in that place, in the manner in which the vehicle is being used. Full stop. Admittedly, the subject vehicle is a transport vehicle which can be used for the purpose of carrying goods. Goods? Goods, not passenger.
Not passenger.
Full stop. When a query is made to the learned counsel for the appellant as to whether the lack of permit in respect of the subject vehicle was a ground taken in the written statement. Full stop. In response, he has fairly submitted that lack of permit in respect of subject vehicle was not taken as a specific, has not been specifically taken as a ground in the written statement filed on behalf of the appellant insurer on 28/5/2014. Full stop. It is noticed that the owner had also filed his written statement stating that the subject vehicle was plied with all relevant vehicular documents, driving license and insurance policy at the relevant time of the accident. Full stop. When the depositions of the claimant's witnesses are perused, it is noticed that both the claimant's witnesses, that is PW1 and PW2, were cross-examined by the owner and the insurer of the respectively of the subject vehicle. Full stop. But no cross-examination was made. But neither the claimants within bracket PW1, neither the claimant within bracket PW1 nor the eyewitness PW2 were cross-examined on the point of lack of permit by the lack of permit in respect of the subject vehicle to ply on the route where the accident took place. Full stop. Had the issue of lack of permit on the part of the owner for the subject vehicle was taken by the appellant insurer in its written statement, it would have been possible for the owner of the subject vehicle to traverse the point and to adduce evidence as regards availability of permit for a subject vehicle or otherwise. Full stop. Now, the appellant, it is not open for the appellant insurer to raise a ground for which foundation has not been laid in the proceedings before the learned tribunal. Had the issue of lack of permit been taken in the either in the written statement or by reducing evidence on his behalf, or even by cross-examination of the prosecution claimant's witnesses, then the issue might have been taken. Then it might have been possible for the appellant to take such point in appeal if the point was decided against it. Full stop. Apart from the issue of lack of permit, the appellant insurer, the learned counsel for the appellant has not urged any other point. Full stop. As such, there is no necessity for the appellate court to deliberate on any other issue. Full stop. Having regard to the above discussion, in view of the above fact situation obtaining in the case and for the region assigned, this court finds that the appeal lacks merit and the same is liable to be dismissed. It is accordingly dismissed.
May I please your lordship? Lordship, here we are to file or reply your lordship to the affidavit by the
Mr.
M. Solo, your lordship.
M. Solo, learned counsel for the petition, has paid for and is granted
2 weeks time, your lordship.
2 weeks time to file affidavit in reply to the affidavit of opposition filed by the
State, your lordship, respond number 1
state
to 3.
respondents. Respond number 1 to 3.
1 to 3, your lordship.
Okay, post of MS,
And reprove.
M,
And reprove.
and Lupayu.
Reprove.
Okay, learned counsel, your state,
For the respondent number 4.
4, and you,
For the state lordship,
okay, MS,
Sibongjang.
okay, so learned state counsel for respond number 1 to 3 and MS so and so, learned counsel for the respond number 4 are present. Please the case after
2 weeks, your lordship.
2 weeks.
Much
Thank you,
lordship.
Lima Wapang.
May I please, lordship?
Yes,
Through writ petition, lordship in WBC 13 of 2022. I received the count only this morning. So Lordship, let this matter come after 2 weeks. If necessary, I file a reply.
Okay, state has filed affidavit.
Yes, Lordship.
Item WBC 13.
13. In 116, bleeding is completed.
Huh?
116, bleeding is completed.
Okay, this 116, item number 14, it is complete.
Yes, it's completed.
And in item number 15, the state has filed affidavit.
Yes, Your Worship.
So you need to file reply.
If so required.
Okay. Mr. Lima Wapang, learned counsel for the petitioners has submitted that the exchange of pleading is complete in respect of the writ petition, WBC number 116/2021. Full stop. In the second writ petition, WBC number 13/2022, he has received a copy of the affidavit of opposition filed on behalf of the state respondents.
Only this morning.
This morning, he has received a copy of the affidavit of opposition filed by the respondent number
1, 2, and 3, Lordship.
1, 2, and 3. Only today. Full stop. He has thus prayed for listing of the case
After 2 weeks, Lordship.
after 2 weeks for filing of an affidavit in reply, if so advised.
Yes.
Okay, the prayer is allowed, list the case after 2 weeks. Cases after 2 weeks.
What you have received the affidavit in opposition filed by the state this morning, Lordship.
Okay.
If this matter can be listed after 3 weeks, Lordship. In the meantime, if necessary, I'll file reply, Lordship.
Mr. Moajami, learned counsel for the petitioner, has submitted that he has received a copy of the state affidavit, state counter. Counter affidavit filed by the state respondents only today.
Lordship.
Okay. So he has thus prayed for listing of the case after 3 weeks. For filing of an affidavit in reply, if so advised to stop. List the case accordingly after 3 weeks.
Lordship. Much obliged.
Much obliged.
Yes.
May it please your Lordship. This revision petition is directed against an order passed by the learned Principal District Judge Dimapur in an application filed by the petitioner under section 142(2) of the Trademark Act, raising the maintainability of the suit. Here, background of this case is that, you know, earlier one Madhusudan Industries was manufacturing and marketing of sanitary and bathroom fittings. And in the year 1980, said Madhusudan company registered its mark Sera in under class 19 and 11 and 19. Subsequently, the ceramic division of that Madhusudan industry has been demerged with the Madhusudan Oil and Fats Company Limited, which was subsequently renamed as Sera Sanitary Ware Limited. So that earlier trademark was registered under the Trade and Mercantile Act, earlier act, and in view of coming into new act in the year 99, the trademark of the petitioners was also registered under the new act of 1999. And petitioner, the product is registered under different classes. And in this case, in particular case, we are concerned about two classes, class 11 and 19. That is relates to the sanitary ware and bathroom fittings. In the year 2010, what happened? The defendant, without taking any permission, without having any registration, while using a mark Glow Sera, deceptively similar to the trademark of Sera. So petitioner issued on 13/9/2010, initially issued a letter Annexure 4, Lordship, in the year Annexure 4, page 53, Lordship. So to which they have replied. Then we again issued reminder notice at Annexure 5 on 13/9/2010. Then we issued another notice on 2/11/2010 to them, to the respondent, to use, asking them to not to use our trademarks. Thereafter, this respondent filed application before the Trademark Authority for registration of their mark Glosera. And when we came to know that, we opposed their applications. And the authority has not registered their trademark. And that is pending. And when we also came to know about this, their applications in the Trademark Journal, it was published. We filed opposition, statutory opposition before the authority trademark register. So then against their refusal to use the trademark Glosera, they filed appeal before the Appellate Authority. And that is still pending. So that during pendency of this appeal, this respondent has filed a suit in the Dimapur court, basically saying that they are using the since 2008, they have a reputation, and they are also doing the same business with the sanitary ware.
Register office at Nagaland.
Register office at Delhi, in Nagaland. But their trademark applications, in their application, as I said, at Delhi. Then one happened.
The cause of action they have shown
Cause of action here,
in a Nagaland.
their contention is that our person came here and said him. So that way they bring the cause of action.
Cause of action, how?
Our person, company personnel,
Company person said.
yes.
Sorry, my registered office in Dimapur, madam. My registered office in
You have
Dimapur.
Registered office.
Yes.
Register office in Lima.
Okay, okay,
But trademark applied at Delhi.
okay.
So then along with this suit, they have filed an application praying for temporary injunction. And the learned court below initially get an interim injunction that was subsequently made final. Against that, we preferred an appeal before this honorable court. And that appeal was dismissed on the ground of delay. Then we moved SLP and the Honorable Apex Court condoned the delay and remand back the matter before this honorable court for fresh disposal. And accordingly, this honorable, after hearing the appeal, dismiss our appeal. Then we again moved the Honorable Supreme Court. The Honorable Apex Court, wide order dated, that order was, that is important, Lordship. Apex Court, page, Annexure 13, page 145, Lordship. 145. Got it, Lordship. Married. The respondent has filed a suit in the district of Dimapur, Nagaland for declaration that his trademark Glosera is not identical to Sera. The trial court granted an injunction on 4/5/2012, which was made absolute on 6/5/2012. The High Court by an order dated 11/3/2009 upheld the injunction granted by the trial court. Agreed by the said order, the petitioner has filed a special petition. No interim order passed by this court effectively. An order of injunction has been substituted for more than 9 years. Mr. Jayanta K. Hemke, learned senior counsel for a petitioner, submit that the suit does not survive in any more in view of section 142(2) of the Trademark Act 1999. The petitioner is at liberty to raise grounds of maintainability survival of the suit in view of the section 142 before the trial court. In any event, the suit was filed in 2012 and it needs to be decided expeditiously by the trial court. The trial court is directed to dispose of the same finally within a period of 6 months from today. So in view of that given liberty to us regarding maintainability of the suit, we have filed an application under basically their suit is under 142(1). Lordship, kindly come to the provision of 142 subsection 1. Section 142 laws. In the under the Trademark Act, there are two types of suit has been filed. One is gauntlet suit And second one is the for infringement of our trademark.
Yes.
142, Lordship. One, their suit is of under 142(1). Where a person by means of circular advertisement or otherwise threaten a person with an action or proceeding for infringement of trademark which is registered or alleged by the first mentioned person to be registered, or with some other like proceeding, a person aggrieve may, whether the person making the threat is or is not the registered owner or the registered user of the trademark, bring a suit being against the first mentioned person and may obtain a declaration to the effect that threat are unjustifiable and injunction against continuance of the threat, and may recover such damages, if any, as he has sustained, unless the first mentioned person satisfy the court that the trademark is registered and that the act in respect of which the proceeding were threatened constitute, or if done, would constitute an infringement of the trademark. If a registered user threaten, they are using the threaten, then this next provision is important. The last proceeding subsection does not apply if the registered proprietor of the trademark or a registered user acting in pursuance of subsection 1 of 52 with due diligence commence and prosecute an action against the person threatened for infringement of such trade. So here, in this case, we have issued letter, we being the registered owner of the trademark, Sarah, has issued 2 letters to them and file opposition before the trademark registry to not to use our trademark. And thereafter, after filing this suit, we have also filed a suit at Ahmedabad for infringement our trademark. That suit is also pending. So
What stage?
in the stage of notice of motion.
No, why? Notice of motion till now, 10 years.
Because but
By way of order, we did 4 interim order of 4/5/12 and 6/12/12. There were observations that the mark is not similar to them. We had filed suit to declare that mark is similar. Therefore, we had not contested both the sides and not argued notice of motion obtained.
both the parties are not
I'm sorry,
wanted.
I'm sorry. I am defendant there. I never say that I am not ready to argue the matter in the trial court at Ahmedabad, my lord. My friend might be saying that both the party, no, man, absolutely not.
He's not agreeing. Anyway, that is pending till death lawsuit. So that is in that circumstances. So we have filed the application under 142(2). This suit is not maintainable in view of the fact that we are the registered owner of the trademark, Sarah, and being a registered trademark holder, we have issued the notices as well as the file the opposition before the authority due diligently to protect our trademark. So that doesn't constitute a groundless threat. Our application is at page for
What is the suit in Dimapur?
in Dimapur suit, lordship. Dimapur suit at page annexure 9, page 76, lordship. In the first page, Your Honor, the suit for declaration and perpetual injunction under the Trademark Act 99 and the Copyright Act 1957. A similar perimetria provision has been incorporated in the Copyright Act also, section 60. So their averment basically comes at page 78, Lordship, paragraph number 3. May I read, Lordship?
Yes.
That the plaintiff has started their business activities for said goods in the year 2008. The plaintiff has honestly and bona fidely adopted trademark Glosera, coined and invented from the name of company Global Ceramic Private Limited in the year 2008. And since then, the plaintiff is using trademark Glosera for said goods. The plaintiff has also adopted deceptive artwork in the year 2008 for trademark Glossera, which catches the eye of the purchasing people. Copy of the trademark Glossera is produced with separate list. Plaintiff submit that the hereinafter for the sake of review trademark Glossera is referred as said mark. Next para 5 is important. That to distinguish the said goods from the goods of the other firm, company and person, the plaintiff has adopted distinctive trademark Glossera with distinctive artwork. The plaintiff has adopted the trademark Glossera after verifying from the record of the trademark, that is important, registry, and also para 5. What's you got? The plaintiff has adopted second line. Plaintiff has adopted trademark Glossera after verifying from the record of the trademark registry and also market and after made survey in the registry and market that the whether any person, firm or any company are using any identical and or deceptively similar mark as to that of the plaintiff trademark in the same trade channel. And when the plaintiff has found that no person, firm and or company are using any identical and or deceptively similar in the same trade, and thereafter the plaintiff has adopted trademark Glossera from their name of the company, and hence the adoption of mark.
But what are the prayers means?
Here prayer,
We'll go into that later on.
page 89, Lordship. Before that, Lordship, come to page 88. That is relief and Lordship. Paragraph 28, let's got it.
Yes.
That the plaintiff is having the address working for gain and residing within the territorial jurisdiction of this honorable court. The plaintiff submit that the defendant has issued groundless writ for infringement of trademark to the plaintiff within the jurisdiction of this honorable court. Hence, under the provision of section 142 of the Trademark Act, this honorable court is empowered to entertain the present suit and grant relief as prayed for therein. The plaintiff further submits that the defendant has also issued groundless writ for infringement of the copyright to the plaintiff within the jurisdiction of this honorable court. Hence, under the provisions of section 60 of the Copyright Act 1957, this honorable court is empowered to entertain the present suit and grant relief as prayed for. The plaintiff further says that the defendant has given groundless within the territorial jurisdiction of this honorable court. Hence, this honorable court is also empowered to entertain the present suit as per provision of the section 20 of the CPC. Then also the plaintiff submits that the cause of action for the part of cause of action has been arisen within the territorial jurisdiction of this honorable court, thereby as per provision of the Trademark Act 1999, the Copyright Act 1957 and CPC. This honorable court is empowered to entertain the suit and grant relief as prayed for. Now their prayer at page 89. Yes, time is. First prayer is the please to declare that the threats given by the defendant to the plaintiff for infringement of trademark, passing of action and infringement of copyright are groundless threat and unjustifiable. Second, trademark Glossera and plaintiffs is of the plaintiff is not identical and or deceptively similar to the trademark Sera of the defendant, and also the artwork of Glossera of the plaintiff is not a substantial and or material reproduction of the artwork of the defendant, artwork of the Sera. And third is restrain the defendant, their servants.
Okay, that is okay. Now prayer 2.
Yes.
Now, suppose prayer 1 is concerned.
Yes.
With the institution of a suit.
Yes.
Under subsection 2 of section 142.
Yes.
Whether this deceptively similar, all these things.
Yes.
Are considered to be subsumed in the prayer.
Yes.
Filed at Ahmedabad.
Yes.
No,
lots of here.
No,
yes.
Tell me very in layman's language.
Yes.
You use Sera.
Yes.
They use Glossera.
Yes.
Now, trademark registered owner of a trademark.
Yes.
Now they have instituted a suit on the basis of trade.
Yes.
And purportedly claiming to be a registered owner of a trademark.
Yes.
This is another issue.
Yes.
That is under subsection 1 of section
One.
142.
Yes,
Subsection 2
yes,
says that there are other issues so deceptively similar or something like that.
yes,
Now, you being a owner of a registered trademark,
yes,
suppose with due diligence has
Yes.
instituted a suit,
yes,
then subsection 1 is redundant.
redundant,
Now, with the prayer
yes,
in the suit subsequently suppose instituted,
yes,
all these issues
Yes.
deceptively similar or
Yes.
something like that will be subsumed in the will consist a part of the suit automatically?
yes, yes,
Automatically?
yes. Page 130 of our Ahmedabad suit, because
No,
this,
I am asking that
Yes.
question. I am not going to the document.
yes,
I am asking whether the law says
yes,
that once the suit is instituted
yes,
under subsection 2 of section 142,
yes,
that all these issues
yes,
like deceptively similar, all
yes,
this will be part of the suit.
yes,
And then in that case, the suit here
yes,
will be not required
yes, infrastructure,
to be contested.
yes. That is
The
the,
authority.
yes,
Any
yes, authority, I have
What is
lots,
your point?
I have lots of
It will
authority.
take
I'm
time
coming,
and this court will not be able to take the issue. First.
the issue is very clear. Two things is most important. First, they have to prove first that they are the registered proprietor of the mark. On the date when they've given me the legal notice, on the day when I file a suit, or on the day when they file a suit, first. Second, is the word used is a due diligence, my lord. That is the most important part, my lord. Lord, what is the situation here?
No, sir, if I go to, I'm sorry, Mr.
Bansali.
Bansali.
Yeah.
Firstly, subsection 1, it is straight.
Yes.
The prime issue is straight. And also it is not that it is to be registered. Alleged by the first mentioned person to be registered. That is also a part. That your first, that submission, that they have to prove, that is not the only requirement. The second part is their alternative. They allege that we are the registered owner of a trademark, alleged to be registered. That also suits the part, subsection 1. Now, if they instituted with such, say, claim, purported claim, instituted a suit. Now, second part is, you can bring a suit under the, against the first mentioned person and may obtain a declaration that the threats are unjustifiable. This is one part. An injunction against the continuance of the threat and may recover such damage as he has sustained unless the first person. These are the requirement for the first person. Then you can claim damage. But subsection 2 is clear. Once it is registered owner, proprietor, does not apply. If the registered proprietor, not registered proprietor of the trademark, it appears primarily that from the earlier sequence of events, they are the registered trademark of a particular mark. Whether it is deceptively similar or not, that is a different issue. Whether with the institution of a suit under subsection 2, all these issues are to be decided by the suit instituted by the first mentioned person.
In the present case, what is the situation? The word, and that's why I'm making clear, my lord. What is the subsection 2 says? I'm again reading this. The last proceeding subsection does not apply if the registered proprietor of the trademark. The first condition is that he should be a registered proprietor of the mark or registered user acting pursuant to subsection 1.
This is not required, registered
Yes,
proprietor of a
right?
trademark.
With due diligence. My lord, this is the important. The second part is with due diligence commence and prosecute an action against the person threatened for the infringement of trademark. So two things. First, defendant has to be a registered proprietor. And second, with the due diligence, if he prosecute, then subsection 1 come in then the suit of this become the infructuous. And that's why I'm hammering on two things, my lord. Neither he is the registered proprietor. I will demonstrate from their own documents, one. Second, due diligence, my lord.
What according to you is not.
Yes, my lord, the thing is that they have issued me the notice in the year 2010. I filed a suit in the year 2012. They appeared, filed reply. Thereafter, the injunction order was passed in my favor, wherein the Honorable Court has categorically mentioned that Sera and Glow Sera is not identical and deceptively similar. And the Sera is a descriptive word. It's derived from the ceramic.
Whether this is only a suit under subsection 1 of section 142 or something.
Yes, my lord. Reason is this because they moved to the higher forum. Their appeal has been dismissed. They moved to the Supreme Court. Their SLP is also been not so injunction order passed by the trial court still in operation till date, my lord. That the mark is not identical and deceptively similar, and the Sera is common to trade.
That will go once it is subsection 2.
My lord, the thing is very clear. That's why, my lord, if we read the order of the Supreme Court, and before I will come to that also, my lord, the date and events are very clear, my lord. First, the first and foremost thing, my lord, that they have to prove that they are the registered proprietor of the mark, my lord. That is the most important part. If I am making one statement that I am the proprietor, that by mere statement, I cannot become a proprietor of that particular mark, my lord. And that's why, my lord, I'm referring, my lord, what is the definition of registered proprietor, my lord? That is section 2V. I'm reading well. Registered proprietor in relation to a trademark means a person for the time being entered in the registered as proprietor of a trademark. So, my lord, first condition is that the defendant has to prove that he is the registered proprietor of the mark. My lord, now the crux has come. If we start with the notice, what is the notice, my lord? Which is at page number 51, my lord. But in notice, there are some typographical error. So what I done, I have prepared one compilation, my lord, because some typographical error was there in the typing of the notice.
Anyway, tell me.
So, my lord,
Page.
they relied on this notice dated 4th August 2010. They relied on two trademarks. That is trademark number 360498 and another was 362970. They claim to be the registered proprietor of the mark, and I read the registered proprietor definition, which shows the name of the defendant should be there on the register, my lord. And that's why, my lord, I produced various documents before the trial court. My lord, last occasion also I pray to the court, let the record of the trial court may be called. The reason is because many documents are not with this revision petition, my lord. Because, my lord, what happens in that also, and here also, my lord, I'm requesting why again, before my lord do something,
Why don't you
certain
bring a
documents.
compilation? Why don't you bring a compilation?
So that's why I brought, I'm giving
By way of an
this. Yes,
affidavit.
I'm giving this.
By way of an affidavit, don't hand it over. I don't accept.
Then, my lord, I need a time to file an
Bring
affidavit.
it on record so that they can respond.
My lord, then I need a time to file the reply, my lord.
Because
With
you have to
affidavit.
serve it.
They have already filed their reply, lordship, though they are not required in the revision petition. After taking adjournments, they have filed already their objection.
Wait.
That is on record, lordship.
Okay.
Well, I filed the reply. Subsequently, my lord, the document produced
along with this revision, which was never the part of the trial court. That contention has been earlier rejected by this honorable court, Lordship. Everything has been read, every documents we have produced before the court. In the WS, we have only annexed the WS without the copies, but we have the copies which we have filed.
You have
And-
filed.
Yes, Lordship. And he's saying that this Sarah is not the registered owner on the date of issuance of the notice. Lordship, kindly go through the notice, first notice, what we have mentioned. Page 51, Lordship.
Now, what say you say document, what documents are not part of the record?
Simply,
I'm just
because
bothering my
that
lord.
Amalgamation order from Odushudan to this Sarah, this document, that was the amalgamated, that document,
Ah.
the High Court judgment of Gujarat High Court judgment was not annexed here. That was annexed in the WS before the lower court. And Lordship, in the first notice, in their reply also to our notice, they have not denied we are not the registered owner. What they are saying, I'm in the next second half, Lordship, from page 51, Lordship. First line, in the first notice, we have given the under instruction from and on behalf of my client Sarah Sanitary Ware, previously known as Messrs. Madhusudan Ceramic, a division of Messrs. Madhusudan Oil Flat, a public limited company established under so and so, so and so, so and so. And what they have replied, page 54. Let's say got it, annexure 5 page, while second paragraph, while we are keen on amicable resolving the matter, it is come to our knowledge that the High Court of Gujarat in 2001 in the matter of Madhusudan Industries, they have the knowledge that we are come from Madhusudan Industries. Versus Regency Sanitary Ware has held that the use of mark Sarah is a generic name derived from the word ceramic and commonly used for ceramic product. They have said that the other company has used, you have lose in the court, but that is not correct. In our reply, that was we have replied that observation was rejected.
Mr. Dekka and Mansali, I think it requires some deliberation.
Lordship,
How much
everything
time?
has been clear. I am producing the case laws. That is a clear case.
How much time you need to reply?
My lord, I need
I have
to
15
reply
minutes
for the 2 weeks only. The reason is this because I'm sorry,
Otherwise, if it is hard,
it will take some time, my lord. At least 2 hours, because I have to deal with each and every aspect, my lord.
that will probably take time.
I will take 15 to 20 minutes. Lordship.
But already time will be over.
Tomorrow, Lordship, remaining. part.
Tomorrow sitting division makes Mr. Dekka. No single bench.
Now, otherwise they are enjoying in infrastructure suit. They are enjoying the injunction against us since last 9 years. Therefore, Honorable Apex Court, without going through the merit of the case, remanded MAC and give us liberty to raise the issue of maintainability.
Right, that was again dismissed by the trial court.
Yes.
So it gives primacy some force to their contention.
Yes.
That was dismissed, your case's application was dismissed by the
Yes.
trial court.
Yes.
So it reinforces their stand to an extent.
Yes. That
Now
extent
this
is.
is to be examined.
Yes,
Why
only
this so?
extended there, only contention is that they have filed this suit not under the 142, but under section 34 of the Specific Relief Act also. Whereas nowhere, not a single aberment, they have filed a suit under section 34 of the Specific Relief Act. And further, for filing a Specific Relief Act 34, he must be a registered owner. I have annexed the document where they have got his registration.
Okay, Mr. Dekka, some other time then. If you
So
want
then,
to
Lordship,
find
let
something-
then we admit for hearing
I
and the
will file
interim
the-
be.
Okay, agree on an agreed date. Next week.
Lord, I have to travel from the Ahmedabad.
We
so I-
both are traveling from Ahmedabad.
Yes.
I and Mr.
Lordship, matter
So
will be
let it be
admitted for
kept-
final hearing
Well,
and
let it
interim
be-
order continue until further order. Then and then they may be fixed for hearing if my as per convenience of my learned friend.
First week of June.
Okay, you
First
choose your
week
date.
of June, my lord. Or
June.
meanwhile, I filed the affidavit in reply also, and I will serve to my friend also.
On 2nd of June, Lordship.
Good enough, 2nd of June.
Yes, Lordship.
Okay, let the matter be admitted.
My lord, I'm sorry, can it be on 5th of June?
No problem. No
You
difference.
can start on a Monday so that you can continue.
Exactly, my lord.
I think better
Yes.
on a Monday.
No difference.
No.
Because tomorrow we'll be sitting in the division bench.
Yes. No.
And Thursday, some
Matter
issue
may be admitted because it will come in the hearing column. It will be easy for us.
because and not that 3-4 matters, about 35 matters.
Yes.
So it will not be possible tomorrow.
5th of May, 5th of June, ma'am.
June.
5th. Monday.
You are available?
Monday, yeah, I am available.
It will be better if you start on a
Sunday can be, in the traveling, it can be used, that's why.
Heard Mr. S. Deka, Learned Counsel for the petitioner, assisted by Mr.
R.D. Mehta.
R.D. Mehta, Learned Counsel for the petition. S. Deka, Learned Counsel, assisted by Mr. R.D. Mehta, Learned Counsel for the petition, Mr. Bansali,
R.H. Bansali.
R.H. Bansali, assisted by Mr. Devnath Dotto,
P.V. Pala.
P.V. Paul, Learned Counsel for the sole respondent.
Yes, madam.
First of, after hearing the Learned Counsel of the parties, it appears that the matter needs further examination. First of, the revision petition is admitted as agreed to by the Learned Counsel for the parties, leaves the case on 5/6/2023. 5/6/2023 for final hearing.
They would waive the formalities.
As the matter is with regard to infringement of alleged infringement of trademark, it is expected that the Learned Counsel part of parties shall not make any prayer for adjournment. The interim order passed shall continue.
Maybe liberty to file the additional reply. ma'am.
Continue till final disposal.
Continue till final disposal of the revision petition.
When you are filing?
First of, if
Bansali? When you are filing?
the respondent may serve the court. Mr. Bansali, counsel for the respondent, has sought leave to file additional pleadings if so advised.
We will file rejoinder within 1 week of their file. We will file rejoinder.
We will exchange in advance, madam.
If any such pleading is filed by the respondent, a copy of the same should be served on the petitioner, who in turn shall file his reply to the said pleadings within 1 week thereafter. But such action pleading must be completed before 1 week.
1 week.
Of 5/6/2023.
Please, madam.
Had it been single bench, I could have taken.
In the order, it says that infringement, that instead of groundless.
LS.
Huh?
LS.
Groundless.
The subject matter is will correct accordingly. Again, that will be a dispute. The disputes I have seen. Okay. Subject matter pertains to trademark sector. That's all. No dispute. No dispute.
No dispute.
Please, madam. Highly obliged.
कौन सा यहाँ पे कॉपी दे नहीं देखो बना के रखा है नौकरी देगी ना India, India to the relax sector. If you say India, dialogue was all whole state. We sincerely. Okay, I'm kidding. You have good, you have taken a good decision earlier, they have intended to hear it, facilitate here, na? That decision is good. No, actually, I was in Silchar, na? So I could not come there. So automatically I contacted there. Yeah. Hey, then, yeah, probably. And they have. What I'm really
May I please, your lordship? Lordship,
Yes.
if I may be allowed to mention item number 35, your lordship, for hearing, your lordship.
35,
32, your lordship.
32.
Yes, your lordship.
Yes.
Lordship, I pray that the matter be listed after 2 weeks, your lordship.
Okay, on the prayer of Mr. M. Solo, learned counsel for the petitioner, comma. The case be listed after 2 weeks, Mr. and Mr.
Penangami, my lord.
Anangami, learned state council. Is present and has no objection.
Much obliged.
Obliged, my lord.
Yes,
Please, your lordship. Lordship, here in this revision petition, in the previous occasion, notice wasn't completed, notice to the sole respondent wasn't completed, so liberty was given to take fresh step. However, as per the record, service is still awaited.
okay, MS.
Gate secret.
Okay, K. Shukru, learned counsel for the petitioner is present. So, in view of the office note dated 31/3/2022, comma, even for the service report in respect of the sole respondent.
Yes, lordship.
Post of list the case after 2 weeks.
Lordship, there is an interim.
The interim order
Yes.
passed earlier shall continue till the next date of listing. Okay,
Much obliged.
May it please your lordship. Lordship, this is a short item, lordship, short matter. It is for compassionate appointment, lordship. The petition is before this honorable court on this fourth occasion, lordship. This is the fourth read petition before this honorable court, lordship. The petitioner's father was serving as Naik under police department. He passed away in the year 2008, lordship. We have submitted applications, lordship. On several occasions, it was not considered.
okay.
And lordship, on the earlier occasion, lordship, when the petitioner approached this honorable court by way of read petition, lordship, direction was issued to the state respondents to consider the case, lordship. In fact, lordship, by the second read petition, lordship, when the second read petition was pending before this honorable court, the state government council has produced a document showing the vacancy status, lordship. So basing on that document, lordship, a direction was issued to consider against any of those vacancies, lordship. However, lordship, there was no specific time frame was given, lordship. We have filed a contempt petition, but this honorable court was of the opinion that no specific time was given. Contempt does not lie, lordship. And this is the fourth read petition, lordship. Now, in this read petition, the state has filed a read petition and a new contention has been raised, which was not raised at any point of time when on the earlier read petitions, lordship. The only contention is that there's a scheme, lordship, 2015 scheme in the state of Nagaland for appointment on compassionate appointment. However, what has happened, lordship, the contention that the state has raised is there's an office memorandum issued in the year 1983, where only 20% is reserved for non-indigenous. I belong to non-indigenous, lordship. I have also enclosed a certificate, lordship. That is the sole condition. The general office memorandum for compassionate appointment does not apply to the case of the present petitioner. That is the contention raised, lordship. And this is at this latest stage, lordship.
What is the general notification?
Lordship, if your lordship may kindly turn to page 14 of my read petition, lordship. Page 14. If your lordship got it, page 14. This is office memorandum dated 17 September 2015. Revised compassionate appointment scheme for state government employees who die in harness, lordship. In supersession of this department's office memorandum of even number dated 6/1/2012. The governor of Nagaland is pleased to revise the existing scheme for appointment on compassionate ground of family member of the state government employees who tie in harness as per the guidelines enumerated below. So these are the guidelines. It's para 2. Appointment on compassionate grounds shall be given only to one of the following members of the deceased employee's family: A, spouse, or son or daughter. Only these are the 3 eligible to be considered, Lordship. The 3 family members, Lordship. Clause 3. Appointment on compassionate grounds shall be made only on regular basis to direct recruitment post and only if regular vacancies meant for that purpose are available in that department where the deceased government employee was serving. Applicants shall have no claim to appointment under this scheme in any other department other than the department where the deceased employee was serving. However, for the NCS officers, the appointment may be considered under the establishment of the Commissioner Nagaland or Nagaland Civil Secretariat, Lordship. 4. Compassionate appointments may be made to the post falling under the combined technical recruitment quota of Group C or D. The ceiling of compassionate appointment of 5%, earlier it was 5%, Lordship, of the direct recruitment vacancies in Group C and D posts have been done away with, provided such appointments do not exceed 50%. No, this is the latest quota, Lordship, of the vacancies during a year. The appointment against posts for direct recruitment in Group C should be in the entry grade only. Further, appointment against any post of direct recruitment in Group C should be limited to those posts which are outside the purview of NPSC for recruitment. 5. The indices seniority of person appointed under scheme shall be fixed with reference to their date of appointment, and their interpolation with the direct recruits appointees shall be made with reference to the dates of appointment without disturbing the interstate seniority of the direct recruits promotees. 6. The scheme will be available to family of the deceased employee provided no serving member of the family holds any regular post in the state government. The benefit of such appointment shall be available to only one family member. The scheme will be applicable. 7, Lordship. The applicants under this scheme should be eligible and qualified for the post in all respects under the provisions of the relevant recruitment rules. No relaxation in eligibility will be made in any circumstance except to the extent provided that this scheme, date of joining of a person appointed under this scheme shall be treated as date of his/her regular appointment. All departments shall maintain a waiting list in chronological order for compassionate appointments. An applicant will be given the waiting list number on receipt of the application. If there are no regular posts available. 8. The upper age limit of applicants under this scheme may be relaxed in exceptional cases up to a maximum of 5 years in addition to existing relaxation. If any, the lower age limit shall, however, in no other case be relaxed below 18 years of age. 9. Appointments under the scheme, irrespective of the appointing authorities specified under the rules, shall be made only with the approval of respective heads of administrative departments with the prior clearance of the Department of PNAR. The department should send proposal for appointment on compassionate ground as per the format enclosed. 10. All departments shall amend their respective service rules, recruitment rules to make a provision for compassionate appointment. This is also important, Lordship. Any dispute arising out of the provisions of this scheme or any clarification shall be referred to the Department of PNAR for decision of the government.
Then what is the first round? First round?
Lordship.
First round, what is the first round decision?
If your Lordship may kindly allow me to turn to page 27, Lordship.
This is the first round?
Yes, Lordship. This is order dated 6/4/2017. May I read the Lordship? The petitioner's case, as submitted by his counsel, is that his father, late so-and-so, was appointed a constable in the police department of Government of Nagaland on so-and-so 1979, but died in harness on 12th of January 2008, when he was posted at Kohima Police Control Room, leaving behind the mother of the petitioner himself and 3 daughters. Since none of the very family members are employed, the petitioner submitted an application to the SP Mokchong, under whom his father served, for appointment in the Department on compassionate ground in the month of February 2008. In spite of verbal assurances, the petitioner was not appointed as requested. Therefore, he submitted another application on so-and-so to the SP Mokchong, which was duly forwarded to the Director General of Police Nagaland, while letter so-and-so. Immediately thereafter, the petitioner also submitted another application in the year 2013 to the Director General of Police Nagaland, requesting for appointment on compassionate ground. But so far, nothing has been done to appoint a petitioner to any job in the department. That the petitioner is a class 12 passed under the Nagaland Board of School Education, and he is well qualified for appointment to the post of constable in the department. Therefore, expecting positive response would come forthwith from the authorities concerned for his appointment, and at the same time, having no means to file a case to claim his right, the petitioner remained quiet for quite some time. But after coming to know that he can avail assistance from Legal Services Authority of the state, he approached the Nagaland State Legal Services Authority for legal assistance, and only thereafter he has been able to come to this court claiming his right for appointment under compassionate ground. The Land Counsel for the petitioner further submitted that under the Government Office so-and-so dated 16/1/2012 issued by the Government of Nagaland, PNAR Department, family members of government servants who tie in harness are entitled to compassionate appointment. And as per the scheme, son of government servant is also one of the eligible persons for appointment. I have considered a prayer of the petitioner and perused the documents filed in support of his claim. And I find that he is entitled to be appointed in the department where his father served and died in earnest on compassionate ground. The respondents are therefore directed to appoint a petitioner in any job to which he is eligible or suitable that as per the scheme provided in the Government Office memorandum mentioned above. With this, read petition is disposed, Lordship.
Okay, second round I have read.
Second is page 29, Lordship. This is order dated 16/8/2018.
Okay, then what happened thereafter?
May I read the relevant portion, Lordship?
I have seen
Oh, Lordship.
page 30, I have seen.
Lordship. Now, contempt, Lordship, page 33. Page 33. Relevant portion is paragraph 3, page 34. May I read it, Lordship?
Yes.
On going through the direction issued by the reed court, it becomes evident that there is a contingency to the direction. It has been directed that if there is a vacancy in the post of constable for appointment on compassionate ground, the petitioner be considered. It has been further been provided that in the case at the present point of time, the petitioner cannot be appointed. He be appointed as and when vacancy arises under that category. This direction has been issued while observing that the petitioner is eligible for appointment under dying in harness scheme. From the contents of this order at issue, it becomes evident that no strict timeline has been provided by the reed court. In such circumstances, I find no reason to take any action against the respondents, contemptors under the Contempt of Courts Act 1971, disposed of.
So this is third, this one is third.
Third, Lordship.
Third read petition.
Yes, Lordship. This is the third read petition, Lordship. May I take your Lordship to page 32, Lordship? This is a communication by the SP to the Director General of Police, Lordship, while pending the second read petition, Lordship. Questionnaire, can I read it, Lordship? Whether the petitioner falls into the office memorandum dated so-and-so 16 January 2012 or as per number so-and-so dated 19 September 1987. The reply is yes, so-and-so is the son of so-and-so who expired on 12/1/2008 after prolonged illness. Second, whether the list of applicant is maintained in respect of the claim on compassionate ground. Yes, a register is maintained to list out the applicant claims for appointment on compassionate ground. Third, whether the present petitioner is in the list for consideration on compassionate ground. The reply is yes, the applicant is enlisted at serial number 1 of the present list maintained at SP office, Motown, Lordship. He featured it serial number 1, Lordship. And the fourth is important, Lordship. The fourth query, Lordship. The reply of the fourth query says that 6 posts of constable is lying vacant at that relevant point of time, Lordship. It was in the year 2018. state has filed their affidavit, Lordship. And in the affidavit, they have enclosed two office memorandum. The first is the office memorandum for compassionate appointment. Second is for reservation of 20% for non-indigenous inhabitants, Lordship.
Now, your case has been rejected.
Lordship,
Hmm?
Lordship.
Your case has been rejected by 16 August 2021. Annexer
Yes, Lordship.
C.
Yes, Lordship.
So this law order is there, then you have to, at least by an IA, you have to put it.
Lordship. While pending this present writ petition, they have taken that decision.
Because
Lordship. Yes, Lordship.
you're pertaining to this now, 2021, this order has been passed.
Lordship,
I think technically you should put a challenge to it
Lordship, Lordship,
by separate writ petition or
Lordship.
by an interlocutory application.
Lordship.
here,
Lordship,
Not by an affidavit in reply,
Lordship.
because an order which is not challenged cannot be set aside in a writ petition. That is the.
I agree, Lordship.
position.
I agree, Lordship.
So for. Yes, what is the stand here? This is the stand. Rejected.
Yes, Lordship.
Better file an interlocutory application. At least.
Lordship.
Just to put it challenge. Many years have gone by. There are two lines of decisions.
Lordship.
One is completion and appointment is to be considered immediately after.
Lordship.
That is one.
Lordship.
Second line, if the much time has gone by,
Lordship.
there is no, if the family has been able to survive,
Lordship.
then
Lordship, it is not a case that I was slipping over on my rights, Lordship. Immediately after
yes.
the petitioner's father
No.
died,
When 2017,
Lordship,
died in 2008,
Lordship.
9 years.
And I have made some applications in the year 2008 itself, Lordship. I have made it in
That will not prolong the period of limitation.
Lordship.
Go through Umesh Nagpal. Umesh Nagpal,
Lordship, Lordship.
which has been relied on by several other judgments as recently as in 2020, 21, 22.
Lordship.
That is Umesh Nagpal.
Lordship.
Write down UMESH Nagpal, NAGPAL, Supreme Court. That
Lordship.
has been relied on consistently by the Supreme Court.
Lordship.
Now, this gap of 9 years might be fatal to you. I'm giving you a chance to challenge this in the interlocutory application, but otherwise, by the ratio laid down in Umesh Nagpal,
Lordship.
because this is not a matter of right. Compassionate appointment is not a matter of right.
Yes, Lordship. I agree, Lordship.
It is by way of grace,
Lordship.
as per the policy.
Yes, Lordship.
So as per the policy, the compassionate appointment is provided to the family so that it can tide over the sudden crisis
Exactly,
befallen upon the family due to the death of the only earning member. Now, if the court finds that the family has been able to tide over the crisis for a period of 9 years, that might be a factor for not consideration
Lordship,
for the court.
Lordship.
So otherwise, I have been consistent holding by following Umesh Nagpal,
Lordship,
and I have some division bench judgment also I have delivered
Lordship,
on the basis of Umesh Nagpal.
Lordship,
9 years is too fatal. Then there are some other Muhammad Syed, which is just opposite,
Lordship,
but that has been again distinguished by Supreme Court
Lordship.
on the basis of Umesh Nagpal, Muhammad Syed or something like that in 2009 judgment, right? There is one 2001 judgment. Just go through it.
Lordship,
There you have, I think you have cited this, but that is not I have just seen in your petition.
Lordship, if I may be allowed to, please reliance on the latest judgment,
Ah.
2022 Lordship
Ah.
and March 2023 Lordship.
By whom?
Honorable Apex Court Lordship.
Ah.
This was decided on 3rd of March 2023 Lordship. May I read the relevant paragraphs, Lordship? 2023 SEC Online SC 219 Lordship. State of West Bengal Lordship.
Yes, paragraph.
Paragraph 3031 Lordship. If your Lordship got it. Paragraph 30 Lordship.
Ah.
The majesty of that is that it is a great leveler for. It makes no distinction between the young and the old or the rich and the poor. That being as a consequence of birth, as at some point of time is inevitable for every being. Thus, while that is certain, its timing is uncertain. Further, a deceased employee does not always leave behind valuable assets. He may at times leave behind poverty to be faced by the immediate members of the family. Therefore, what should be done to ensure that that of an individual does not mean economic debt for his family? The state's obligation in this regard confined to its employees who die in harness. He has given rise to schemes and rules providing for compassionate appointment of an eligible member of his family as an instance of providing immediate succor to such an family. Support for such a provision has been derived from the provisions of Part 4 of the Constitution. That is Article 39 of the Directive Principles of State Policy, Lordship. 31. It may be apposite to refer to the following decisions of this court on the rationale behind the policy or scheme for compassionate appointment and the considerations that ought to guide determination of claims for compassionate appointment. One, Lordship, I'm relying on this. Sushma Gusain's versus Union of India. This court observed that in all claims for appointment on compassionate grounds, there should not be any delay in appointment. That the proposed purpose of providing appointment on compassionate grounds is to mitigate the hardship caused due to the death of the bread earner in the family. Such appointment should therefore be provided immediately to redeem the family in distress.
Then, para 2.
Lordship.
Then go on reading para 2.
Lordship, I agree.
Rohit, go on.
2 has
Umesh Nagpal.
taken
Then
the
it is-
contrary Lordship.
Then
stand.
later judgments have all followed Umesh
Yes,
Nagpal.
Lordship. Yes, Lordship.
Roman 6, 4.5 years, filed after 4.5 years.
Lordship.
This is,
If I may be allowed to rely on the second authority, Lordship.
consistent view. Also, I cannot. So,
I agree, Lordship. I agree, Lordship.
okay, try after 2 weeks.
Lordship.
But Umesh, you take this back. Umesh Nagpal is against you, and all the judgments on basis of Umesh Nagpal is that the time of filing the application,
Yes, Lordship.
because the scheme in Assam
Lordship.
is that the application must be filed within 1 year from the date of death.
Lordship.
Otherwise, out.
Lordship.
the scheme in Assam.
Lordship.
Okay, DD. So this is the limitation period in Assam,
Lordship.
following Umesh Nagpal and all. So here you have filed after 9 years,
Lordship.
and 9 years is too long a day.
Lordship, I agree. Lordship, I agree. Of course, I have made amendments that I have approached.
Notwithstanding the plea they have taken,
Lordship, Lordship.
that indigenous.
Yes, Lordship.
Okay. And try to find additional IA.
Lordship.
Put that challenge because your
Lordship, I'll do that.
case has been rejected.
Lordship.
So this must be challenged somehow.
Lordship. I'm grateful, Lordship.
Okay. Mr. Muajami, learned counsel for the petitioner, has paid for listing of the case. After 2 weeks. In order to find out whether there is any necessity of additional pleading.
Lordship.
MS,
Pijalokitan.
learned state council is.
Yes, Lordship.
I am not said about this
Lordship.
rejection, but you.
Lordship.
better find.
Lordship.
List the case parallel, list the case after 2 weeks.
Much obliged, Lordship.
9 years is fatal appears to be.